With the consent of other side, I beg to mention item number 45 and 48.
May I please
नाम तो लिख दो नाम तो for respondent or petitioner.
For respondent.
Okay. Yes,
may
please.
I please your lordship, lordship, I beg to mention with regard to item number 27, lordship, kindly matter may be adjourned for the day. Obliging.
Give your name and your for whom you appear.
May it please your lordship, I beg to mention item number 20.
You please give your name and get it adjourned. Your name for whom you appear. All allowed. Yes, next.
Item 1 for motion.
Yes.
Application, lordship. Matrimonial dispute, my lord. Husband filed divorce application in Dibrugarh. Wife reside in Guwahati, my lord. So
Where did the marriage take place?
Guwahati.
Guwahati. And where did they reside?
Wife reside now in Guwahati, my lord.
Sorry, no. After marriage, where did they reside?
Dibrugarh.
So Dibrugarh has jurisdiction.
My lord, now he has a breastfeeding baby, my lord. 10-month-old baby. He resides with the family, my lord.
No. What is the law? Under the law, which court will have the jurisdiction?
My lord, when the marriage took place or when they last reside together, my lord. Both. But here is to convenience of the wife has to be looked into, my lord.
Heard Mr. M. Chiladichal and counsel for the petitioner. The petitioner Poonam Das, who is the wife of the respondent Jayaprakash Hatimuria, has instituted this petition under Section 24 of the CPC for transfer of the title divorce suit 95 to 2023, filed by the husband respondent before the learned district judge Dibrugarh, on the ground that the marriage took place in Guwahati, although the parties after marriage have resided in Dibrugarh, but after they have started living separately, the wife is presently residing at Guwahati and as a breastfeeding child, and therefore it would be inconvenient for her to attend to the proceeding at Dibrugarh in view of the prima facie case being made out. Further proceeding in title divorce suit 95/2023 pending before the learned district judge Dibrugarh be stayed until further orders. Further consideration of the interim order would be made upon appearance of the respondent. Issue notice, return about 6 weeks. Steps were registered post 3 days.
Right.
Item 2.
Otherwise, my lord, if not state, my lord, have to appear on is the 10th, my lord, this month. That will be difficult, my lord. Generally, my lord, if the notice the issues, my lord, regarding transfer.
So you don't want an interim order? Interim order to recall Korok? Yes, next item.
Interim order is required, my lord.
If you don't want an interim order, tell us, we'll recall it.
Right.
If you want to, we have already granted.
That's fine.
Yes.
Sorry.
Yes, item 2.
Item 2.
Against the order of rejection of injunction. There is a dispute boundary and after construction of my building, 3-story building, my lord, they have raised the objection and filed a petition before the municipal court. And municipality court, Nolbari, 45-43, my lord, issue after inspection, direction, directed us by input notice for demolition without hearing me. Because, my lord,
No. What is the order passed by the learned civil judge senior division?
senior division, my lord, appeal, my lord.
No. This order dated 15/9/2023. What is this order?
15-9, my lord. It is appellate order, my lord.
Understand. What does it provide for?
My lord.
What does the order provide for?
My lord,
Page number? Which page is that order available?
my lord, Miss Appeal, page 74, my lord.
74.
4, my lord. Again, my lord, injunction or rejection of the injunction order, we prefer Miss Appeal, my lord.
It's against a rejection of injunction
Rejection of injunction.
by the trial court as well as by the appellate court.
Now we have come in revision, my lord. Because.
So we issue notice.
Yes, my lord. That
we-
aspect should be maintained, my lord, because we have constructed, we are in possession. And there is a compromise, earlier there is a compromise. On the basis of compromise, we have reduced our newly constructed wall. Leaving 2 feet space. my lord.
The appellant petitioner is the plaintiff.
Yes,
What is the relief sought for in the title suit?
cancellation of that demolition notice, my lord. On the behest of the
Demolition notice by whom?
municipality.
The-
He has filed
Where is that notice? Which page?
my lord, at page 50, my lord,
15,
50, 50.
50.
Sorry, my lord, not 50,
Hmm.
52, my lord.
52.
His notice was issued, my lord, on the behest of my lord, the private person, respondent number 3, my lord. He was complaining, he is the neighbor, my lord, and he has constructed without.
And before the trial court, what is the stand of the municipal authority?
They have stated that on the basis of our inquiry, my lord, there is a reduction of the space side back. They stated that it is 2 feet instead of 5 feet, my lord, but without our hearing, my lord. They determine the original wall, my lord.
No, you were directed to appear before the municipal on 18/11/2022.
Yes, my lord. We have given the
So
we appear.
question of hearing possibly does not arise. They have given you notice.
Notice was given for producing our document for permission.
Understand whatever it
We
is.
have given, my lord.
That is a part of the hearing.
Subsequently, they have made inspection. At that time, my lord, no hearing was given because
But no, but one aspect we are interested in page 52, it only says in violation of the prescribed setback rule by
yes,
2 feet
2 feet.
instead of 5 feet. You are directed to remove.
The wall, my lord,
Why do you say this notice is wrong?
because, my lord, the wall was constructed as per agreement with the oral agreement with the neighbor, my lord. We have reduced the space and we have constructed the wall, my lord, particular boundary wall in our land, my lord. From that line, it is violation, my lord. But beyond the wall, there is a land. So without demarcation of the original wall, my lord. That is the point, my lord, because,
The building was constructed.
yes, my lord,
Then there was a dispute with the neighbor.
yes, my lord.
After the dispute, it was resolved that you'll bring back the wall by 3 feet.
Oh, yes, my lord. We have,
So now, after the wall is brought back by 3 feet, there is a violation.
yes, my lord. So if my land is beyond wall, then it is not violation. And there
Where is that agreement?
my lord,
Where is that agreement with the neighbor?
no, the oral agreement, my lord. Subsequently, we have stated that subsequently he demanded money, my lord. Now also, we are trying to compromise. The municipality authority also insists us for compromise, my lord. They are not.
And some violation can be compounded. Is it
Yes,
within
my
that
lord.
limit?
That is, my lord, whether it is within the compoundable deviation. Compoundable deviation, my lord.
Is it within the compoundable deviation?
As per their, my lord.
Not there.
it
As
is-
per the law, is it?
2 feet is there, my lord, then it is not compoundable, my lord. 0.15 is deviation, my lord.
Where is that law?
Law is there, my lord. My lord, probably book is not available in the court, my lord.
সেইখন আছে নেকি?
Assam notified urban area other than Guwahati building routes 2014.
Same
Yes,
book.
Page
Which-
30, same.
30?
Page 32. My lord, page 32,
Mhm.
subsection 3, my lord. Any deviation from approved plan shall be corrected by demolition of the
Where are you reading? Acha, page 32.
page 30, subsection 3, my lord. Any deviation from the approved plan shall be corrected by the demolition of the unauthorized part of the construction, except that of a building or part thereof has been constructed without obtaining the required building permit, from the authority, but in conformity with the building bylaw. Tolerance in case of dimensional errors.
And where is the building bylaws?
Building bylaws, my lord.
Hmm.
Conformity building bylaw. Building bylaw.
No, there is a provision for compounding the offense.
That is, my lord, here permitted up to 1.15.
The-
My last line, my lord. Below, tolerance in case of dimensional errors shall be permitted up to 1.5 meter. So, my lord, for that purpose, my lord, evidence and particular metals must be there. my
So
lord.
now ultimately, what will you do?
My lord,
If your existing wall remains, it's a deviation
no,
and
this,
law does not allow you to compound.
this one is.
So either two ways out for you.
Yes, ma'am.
Either you demolish a part of the building or you demolish that wall.
Well, if I,
You demolish the wall,
then, my lord,
go back to
That
your
is what-
original boundary
that
and
is
then show to the authority there is no deviation.
yes, my lord, that is the problem, but they should have, my lord, taking the assistance of the revenue authority, because land, whereas the actual demarcation of the land, that is not there, my lord. They have measure on the basis of my wall, my lord, which is constructed in my land. Yeah, so, my lord, at this stage, my lord, yeah,
Where is that pleading?
my lord.
That it is, you have brought back the wall by 2-3 feet.
Uh, Please 13, my lord.
Page 13.
Please 13, please, my lord.
13 is the plaint.
Plain, my lord.
Where is that you have brought back the wall?
There is saying that there is, as per their case 4, my lord, the defendant number 3 already constructed a house on his. his land.
No.
Because the defendant number,
Where is your pleading that with some oral agreement, you
Yes,
have
ma'am.
brought back the wall by 3 feet and you have land beyond that wall?
my lord, the page, para 4 itself, that defendant number 3 already constructed a house.
No,
on
that
his
I
land.
have read.
So,
Was
below,
it
my lord.
understanding with
Towards the land of the defendant, number 3 was in understanding.
No, but you have not stated that you have your own land beyond the wall.
Understood with the plaintiff, that both will leave 2 feet space.
But,
on the boundary.
but two private persons cannot agree among themselves that we both of us will violate the building
Yes,
laws.
my lord, that cannot.
That cannot
That
be.
cannot be made. But my lord,
But what you are saying that you have land beyond the wall, we are interested in that statement.
that statement is that both of them leave 2 feet space on the common
But,
boundary.
but this will not give you any legal right.
I have no legal right, my lord, but I have.
No, we are thinking of providing something different.
Yes.
If I can get an averment from the petitioner that there are land of the petitioner beyond the wall, if you make that averment, we may think of some order in your favor.
My lord,
But that statement is not there.
statement is that, but.
You file an affidavit.
Yes.
Mr. Decca, what we intend
Yes,
to do
yes.
is straight away, I can't declare a prima facie right in your favor because it is
Yes.
an admitted violation of the building bylaws.
Yes.
But the case you are trying to project that I have brought back my boundary wall by 3 feet,
Yes.
although my land exists beyond the wall, then we may
Yes.
give liberty to the municipality to take it up with the revenue authorities,
Yes,
have your land measured. If there is land beyond the wall,
then I will be protected.
you'll be.
Then I'll file
But
the-
that statement we need.
Yes, my lord.
That will be the core basis of our order, but we need that statement. It's not there. Heard Mr. P.S. Dekal, senior counsel for the petitioner. By instituting that TS 1/2022 in the court of the Municipality number 1 Nalbari. Notice of the Nalbari Municipal Board dated 17/12/2022 is assailed. By the notice of 17/12/2022 under which provision? 32(3), this notice under so and so of the petitioner is required to remove an unauthorized part of the building on the ground that it violates the rear setback to the extent that the existing setback is 2 feet, whereas under the law, 5 feet of setback is required. Both the trial court in its order dated 27/7/2023 in Ms. J case 7/2023 and the learned appellate court by the order dated 15/9/2023 in Miss Appeal 03/2023 had declined injunction in favor of the petitioner. Mr. P.S. Dekar, Learned Senior Counsel, also refers to the provisions of section 32(3) of the Assam Notified Urban Areas bracket other than Guwahati Building Rules 2014, which provides that an unauthorized construction in deviation of the building rules can be compounded up to a deviation of 0.15 meters. Admittedly, when there is a deviation of 3 feet, it would be beyond 0.15 meters, and therefore we do not notice any infirmity in the order of the learned trial court as well as the appellate court, in as much as a prima facie case being made out by the petitioner. But we have taken note of a statement of Mr. P.S. Dekar, Learned Senior Counsel, that the notice of the municipality had been instituted on the basis of a complaint lodged by the respondent number 3, namely Muhammad Islam Ali, where the petitioner Salahuddin Ahmed and the respondent number 3, Muhammad Islam Ali, are both neighbors. And out of an oral compromise between the petitioner and the respondent number 3, the back wall of the petitioner was brought forward by about 3 feet, meaning thereby that the petitioner claims that the petitioner also has land of 3 feet beyond the wall that is presently existing.
Not legal, some land.
Some land existing. According to the petitioner, if the actual land of the if his actual land can be measured by the revenue authorities, and it can be noticed that he has land beyond the existing wall, it would be possible for the petitioner to demolish the wall and construct a new wall, which may be in conformity with the requirements of the building bylaws. In view of the above, an adjournment is sought for by Mr. P.S. Dekar to bring it on record that there was a compromise between the petitioner and the respondent number 3, requiring, which resulted in the back wall of the petitioner being brought forward. And if the land of the petitioner is taken into account, there may not be any violation of the building bylaws. Prayer for adjournment allowed. List on. Make it early, faster. Don't take a long time.
Yes.
1 week,
1 week.
list on so and so for further consideration till the next returnable date. The demolition notice dated so and so of the non-dwelling shall not be acted upon.
Not right. Item 3.
Yes, Mr. Bhatti.
My lord, I have presented the judgment and order dated 31/7/2023.
Page number
Case number 31, my lord.
31.
And, My reference was rejected only on 2 grounds. First ground, my lord, on the question of limitation. And second-
31 is a written statement of somebody.
Yes, written statement, the opposite party have also filed the written statement.
No, no. Which order if you have challenged? You have challenged the written statement.
No, judgment and order, my lord.
Huh?
That is at page 35, my lord.
35, huh? Not
Sorry,
31.
30. Only on 2 grounds, my lord.
Mhm.
First ground is of limitation. And
This is
second
some
ground
LA
is
case.
of necessity.
And who is Kundanmal White? He is a landowner.
Yes,
And
his land was acquired by
his land was acquired by the state.
state
And in whose favor the land was acquired?
in favor of one, my lord.
IW80.
Sorry,
IW80, Lord.
IW80. Are they not a necessary respondent in this proceeding?
Yes, Lord. They are necessary proper respondent, Lord. They are not made a party on that ground. It was
You implead them. This is apparently an order possibly in favor of the party in whose favor the land is acquired.
Yes.
Make him a respondent. We'll pass the order.
indeed.
Mr.
I-
O.P. Bhati learns counsel for the
I will-
petitioner seeks for an adjournment to incorporate necessary correction for impleading the acquiring for impleading the beneficiary of the land acquisition as a respondent. List on that. Next week.
In the LA case also, Lord, they are not made a party, Lord. On that ground, it was dismissed, Lord.
Sorry.
In the LA case, Lordship, IW80.
Acha, they are not a
not
party.
a party, Lord. On that, this particular.
I think you have to correct it, Mr. Bhati.
My lord, even though,
Suppose
yes,
today in my favor, your land is acquired and Madam Das is the DC. Moment compensation is determined.
Yes.
A legal right flows in my favor that this is the amount I'll give.
Yes.
Now, if the landowner wants more amount, I'll have to be noticed.
that is, your lordship is absolutely right, man.
Mr.
But
Bhati, we are not only right, we are absolutely right.
But
And there is a requirement of law, otherwise we are dismissing your appeal.
my lord, this.
If you want to do the correction, we give you the liberty. If you don't want to do,
Yes.
we'll
Yes,
pass
my
an
lord,
order
the
against
liberty
you.
may kindly be given and I will.
Okay. Okay. It is submitted by MS D.D. Borman, learned additional Senegal advocate, that the party in whose favor the land was acquired had not been made a respondent even in the LA case before the learned appellate court.
It is not this.
Before the learned additional district judge. Mr. Bhati seeks for an adjournment to do the necessary correction. List on when you want.
After.
You incorporate the corrections, come back, we'll pass the order.
After 7 days,
After one fixed date or after 7 days?
after 7 days.
After 7, list after 7 days is paid for. Yes,
Not-
next item.
Item
My
4.
lord, I don't know, I will say.
Same. Make them a party in the LA case. Make them a respondent
My
here.
lord,
we'll
the
hear
case
you.
is already been dismissed. That is the
Dismissed, Lord.
position, by.
Sorry,
That case is dismissed, Lordship. On that
That
ground.
case
Lord.
is already been dismissed on that ground. by.
on that ground alone.
Yes, that's why.
And limitation also.
No, limitation, we'll hear it separately.
And both the grounds which have been taken are not correctly decided by the.
We are not expressing anything in merit against you. Acha, in the LA case,
Yes,
the acquiring department was not made a party. And was the appeal dismissed on that ground alone?
Yes.
two grounds,
On limitation
limitation
And also on that.
non-joined or necessary party.
So in this CRP, will there be a necessary party, or we can dispose of giving him the liberty to implead them?
Yes, Lord. The necessary party before that.
Understand,
appeal, Lordship.
in this revision petition,
Yes, Lord.
can we allow the petition giving him the liberty to implead that acquiring department and to
Process.
proceed accordingly? Or in this CRP also, the acquiring department will be a necessary party? I think they will be a necessary party.
Necessary party.
We will have to hear them.
Yes, Lord. After.
You implead them in this proceeding.
Yes, Lord.
Next week.
Item 4.
Same, item 5.
is there.
Sorry. Same, adjourn on the prayer mention for necessary correction in the area of the respondents. It will given delay. 4.
May please your lordship, this petition is preferred lordship for initiation of contempt proceeding by the lordship civil judge Kokrajar lordship. Here lordship, the
Where is that order?
order lordship, first order is lordship page 42 to 44 lordship.
42 to 44.
Lordship page 44 lordship.
Just a minute.
First one, they have preferred their title suit lordship, their second wife, for declaration of right title interest in the pensionary benefit of the deceased husband lordship, against the first wife. And they have filed also one miscase.
No, just a minute. Second wife has filed a title suit
Lordship,
against the first wife,
first wife lordship.
claiming right title and
Right
interest over the pensionary benefit.
Pensionary
And what order was passed?
Lordship and lordship one miscase was also filed lordship for state of proceeding. Instead of release of the amount lordship.
Okay, now, after that, what order
After
was
that,
passed?
lordship, in the miscase lordship, page 44 lordship.
Page
Page 44
44. Parties are represented. Who are they? Sinnamai Basumatari and Minoti Sarkar.
Lordship.
Minoti Sarkar, first wife.
Minoti Sarkar first wife lordship.
Sinnamai.
And
So now why is the Union of India
Yes,
before the court?
SSB is a party in the title suit lordship. SSB is the party in the title suit, but in the miscase where they have passed the order lordship, in that miscase SSB was not made a party lordship. And in that regard, we have no objection. Otherwise, lordship, the order is against us lordship. The
Okay, where is the order?
page 44 lordship. Page 44, last 5 lines lordship. However, for the peculiar facts and circumstances of the case, the DD of the late Gauranga Chandra Sarkar is at the liberty to disburse 8% of the service. It should be 80% lordship. Service benefit to the late Gauranga Chandra Sarkar in favor of the opposite parties.
I think we have decided this issue in the full bench.
Lordship, regarding contempt jurisdiction.
No. Regarding entitlement of a second wife
Second.
has been decided in by a full
Lordship,
bench.
sitting in a full bench, that was decided.
Ah,
But here, on that point, we are not coming, lordship.
no, you may not come.
Lordship.
But this order appears to be in conflict with the full bench judgment.
That is their lordship. But subsequent order is there, lordship. May kindly pause for a moment, lordship.
Which page?
Lordship. Then lordship, however, for the peculiar facts and circumstances of the case, that was passed away. Against this order, lordship, they have preferred an appeal, lordship.
In favor of the open and for remain. No, civil judge cannot pass this order.
Lordship.
Civil judge cannot pass an order requiring the departmental authorities
Lordship.
to give 8% of the pension to the second wife.
Lordship.
They don't have that jurisdiction
They have.
in view of the full bench
When that's why
judgment.
it should be lordship. Lordship already decided that.
Full bench will be declaration of title
Title lordship.
by the second wife against the first wife claiming some money. There is no role of the departmental authority.
Lordship.
And the money will be paid to the first wife
And she will.
and the first wife will pay it to the second wife.
Lordship.
That is the law.
That
Check,
is
please take
lordship
up.
already decided.
Ah,
But lordship, against this order, lordship, the petitioner has preferred an appeal, lordship.
that is the first wife.
Second wife preferred an appeal, lordship.
No, second wife, this order was in her favor.
Order was in her favor, but he is not satisfied. He is preferred an appeal.
What's 8% not satisfied?
20%. 8% should be 80% in favor of the first wife, Lordship.
Hmm.
Typographical mistake it is. So Lordship may, if peruse it.
Okay, it should be
80%.
80%.
80% service
Heard
benefit
about
in favor of the opposite party, that is the first wife, Lordship. And for the remaining 20%, Lordship,
Admitted for hearing. That is page 45.
page 44, Lordship.
No, 44 I have read.
Lordship.
After
And
that,
after that, page 45, she has second wife.
wife
party is
appeal. Here
And-
only notice is issued.
No, Lordship. Lordship may kindly from bottom 9 line, Lordship. Hence, Lordship.
Hence, the appeal is
for
admitted
hearing,
for hearing
the
and the
impugn order is
impugn order is stayed.
Stayed till the disposal of the appeal.
Very well.
Whole order was stayed, Lordship. Against this, Lordship, after that, Lordship, they have preferred and Lordship contempt petition, Lordship.
Who?
The second wife,
Against whom?
against the SSB authority.
Why?
The on submission is that, Lordship, we have released the pensionary benefit to the petition. Opposite party number 1.
No. Second wife obtained this order at page 44.
Lordship.
First wife goes in appeal, gets it stayed.
No. Second wife goes in appeal.
Goes in appeal and gets it stayed.
Yes, the whole order was stayed by the court.
If whole order is stayed, it is stayed.
State, Lordship, there is no any contempt proceeding, Lordship. We are come against that, Lordship. The contempt proceeding initiated by the Lordship civil judge, although they have the not jurisdiction to the
Where is that contempt note?
page 46, Lordship. Page 46, Lordship.
To the area organizer, that one.
Lordship. Although we are not made a party in the miscase as well as Lordship misappeal also, Lordship.
Contempt action, no?
As per section 10 to 15, Lordship, only the jurisdiction is the only High Court is the
That's what
jurisdiction.
we are trying to look.
Lordship.
I think the civil judge does not
Civil
have the
judge,
contempt
he
jurisdiction.
cannot, Lordship. He cannot. Even, Lordship, the whole order was state, Lordship. In the state order, Lordship, there cannot be a contempt also, Lordship. Section 10 to 15, Lordship. And Lordship, initiation of registration of contempt proceeding is page 89, Lordship. The order of the court, Lordship.
This is only notice. Where is the order of the court?
Lordship, my lord, by page 89, Lordship.
89.
Page 89, Lordship. They have registered the contempt petition. Petition is registered as miscontempt case law by under section 2B and 12, Lordship. They have the beyond the jurisdiction, they have acted. Lordship.
12 to B of the Contempt Act.
Lordship. 2B and 12, Lordship. Section 2B and 12, Lordship. To be for civil contempt, Lordship, and 12 for punishment for contempt, Lordship.
আগৰটো দীঘল হৈছে নহয় চেঞ্জ আগৰটো দীঘল হৈছে চেঞ্জ কৰি দিয়া এইটো দীঘল হ'ব
And Lordship, subsequently the appeal. In the meantime, Lordship, the appeal was also disposed of, Lordship. Appeal was also disposed of.
No, we are not going
No,
to
Lordship.
those aspects. Heard Mr. K. Gogoi and counsel for the petitioner. Title suit 27/2018 had been instituted by Chinamai Basumatari Elias Sarkar, wife of late Goranga Chandra Sarkar, in the court of the Munsif at Kokrajar, against the respondent number 1, 2, and 1, 2,
3 and 4
3,
Lordship.
and 4, respectively being the wife and children of the first wife of the deceased Goranga Chandra Sarkar. The petitioner Chinamani is being the second wife had instituted. The petitioner's second wife claims for a portion of the pensionary benefits of the deceased Goranga Chandra Sarkar. And in the proceeding, the departmental authorities where the deceased Goranga Chandra Sarkar had worked, namely the area manager.
Lordship, it should be deputy inspector.
No, who is impleaded?
In the original petition, they have
That-
included Lordship the Deputy Inspector General.
No, where is the plaint?
Plain Lordship, page 16 Lordship, page 16. You start from page 15 and page 16 is the
Wherein the wherein the apparatus is going on. Wherein the Director General Government of India in the Ministry of Home Affairs, Sasastra Sima Bal, comma, the Inspector General Sasastra Sima Bal, comma, the Deputy Inspector General Sasastra Sima Bal, and the area organizer Sasastra Sima Bal at Kokrajar were impleaded as were arrayed as pro forma defendants. By the order dated 9/9/2019 in Ms. J case 17/2018, comma, amongst others, the following order as extracted was passed. Page 44 in this case or pura loi phale. It will be red to red. It has been informed that the expression 8% in the order dated 9/9/2019 is to be read to be 80%, and it is a typographical error. The purport of the order of the learned Munsif is that the departmental authorities would be at liberty to disperse 80% of the pensionary benefit of the deceased Goranga Chandra Sarkar in favor of the respondents, Minoti Sarkar and others, whereas the remaining 20% be withheld till the disposal of the title suit 27/2018. The plaintiff, what was that name? Other lady? Plaintiff Chinamai Basundari alias Sarkar instituted. Where is the case number, Mr. Gogoi?
Lordship, case number is 3 of 19 Lordship.
Where do you get it? Instituted appeal case number 3/2019 before the learned civil judge Kokrajar. And in the appeal, comma, by the order dated 24/9/2019, the earlier order of the learned Munsif dated 9/9/2019 was stayed. In the circumstance, the departmental authorities had released the pensionary benefit in favor of the first wife, namely Minoti Sarkar. And in the circumstance colon. In the circumstance colon. In the circumstance accordingly, and in the circumstance. The respondent Chinamai Basumandari Alai Sarkar had instituted miscontempt case number 01/2022 before the learned civil judge Kokrajar. We have the petition.
Miss petition.
That the contempt case.
Page 47, Lordship.
47.
Page 47, Lordship.
From a reading of the petition in miscontempt case 1/2022, it is noticed that the said application is under section 2B, read with section 12 of the Contempt of Courts Act. The learned civil judge, by the order dated 21/2022, had registered the contempt matter and accordingly issued notice and fixed the matter for hearing. Where is the contempt notice again?
Contempt notice.
Page,
Lordship,
I think, 46, I think.
46.
Accordingly, under the signature of the learned civil judge Kokrajar, dated 14/7/2022, a notice of contempt was issued amongst others to the area organizer Sasastra Sima Ball at Bongaigaon, in the office of the Deputy Inspector General at Bongaigaon. Being aggrieved, the Union of India, through the Sasastra Sima Ball, has instituted this petition under section
Article 227.
227.
Lordship.
Under section 2, article 227 of the Constitution of India. Firstly, it is noticed that the learned Munsif had passed the order dated 9/9/2019, allowing the departmental authorities under the Sasastra Sima Ball to disburse 80% of the pensionary benefit to the first wife, namely Minoti Sarkar, and not to disburse the balance 20%. Against that, the second wife, Sinomai Basumandari alias Sarkar, had went in appeal, and in the appellate appellate court, by the order dated 24/9/2019, had stayed the order dated 9/9/2019 of the learned Munsif. The implication of the stay order passed by the appellate court in respect of the order dated 9/9/2019 would be that even the provision requiring 80% to be disbursed to the first wife Minoti Sarkar and to withhold the balance 20% had also been stayed, and there is no obligation on the departmental authorities to follow the same, meaning thereby that the departmental authorities can proceed in a manner as they had proceeded earlier as regards the disbursement of the entire pensionary benefit to the first wife Minoti Sarkar. From such point of view, no violation of the appellate order dated 24/9/2019 of the learned civil judge is noticed. Secondly, it is also noticed that the contempt petition had been instituted by the second wife, Chinamai Basumandari alias Sarkar, under section 2B, read with section 12 of the Contempt of Courts Act. Section 2B of the Contempt of Courts Act defines civil contempt to be a willful disobedience to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of an undertaking given to a court. As already noticed, no such act on the part of the present petitioner, being the authorities under the Sosostosima Ball, is noticed as regards any willful disobedience of any judgment, decree, direction, order, writ, or other process of the court, or any willful breach of an undertaking given to a court. Secondly, it is also noticed that the contempt petition had been instituted under Section 12 of the Contempt of Courts Act 1971. Section 12 of the Contempt of Courts Act is as extracted, which provides for the punishment of simple imprisonment with a term which may extend to 6 months, or fine which may extend to 2,000, to be made by a contempt court. They punished sentence to Korea by a lage. But Section 12 has to be read along with Section 11 of the Contempt Courts Act 1971 in order to determine as to which court would have the jurisdiction to issue to register a contempt proceeding and to issue contempt notice. Section 11 is as extracted. A reading of the provisions Section 11 makes it explicit that it is only the High Court which shall have the jurisdiction to inquire into or try a contempt of itself or any other court subordinate to it. Section 12 makes it further explicit that the High Court will have the jurisdiction to inquire into or try a contempt either of itself or of a court subordinate to it, meaning thereby, even if there is a violation of an order of the learned civil judge, it will be the High Court which will have the jurisdiction to inquire or try for a contempt of any such order. From such point of view, it is prima facie noticed that the learned civil judge Kokrajar did not have the jurisdiction under Section 12 of the Contempt of Courts Act to either register the contempt proceeding in miscontempt case so-and-so, or to issue a contempt notice upon the petitioners being the authorities under the Sosostosima Ball. Considering the balance of convenience and the irreparable loss that the petitioner may suffer, the contempt proceeding in miscontempt case number 1, I think, 1 of 2022, before the learned civil judge Kokrajar shall remain stayed until further orders. Call for the records of this case. So.
Item 6. Item 6.
Yes, Mr. Ubaida. CRP.
CRP.
Which order?
Challenge by this revision, I have challenged the two orders,
Mm-hmm.
two judgment passed by the learned municipal and also by the
Which page, Mr. Ubaida?
yeah, my lord. This judgment here. Plenty cases of plenty. I am the defendant, my lord. Yes, I am the defendant.
Yes,
Without-
No. Which order is challenged now?
The page
Yes, I the impugned judgment in 19/8/2023 of the civil judge.
title appeal number judgment. My lord,
Which page?
64.
60.
Start from 64.
Yes, please start. Mhm.
the case of the plaintiff is that he purchased a plot of land along with a
Mhm.
building standing there one. And he filed a suit for realization of the rent, also for my ejectment. Stating that I defaulted in payment of rent.
Acha, it's eviction suit. So there is a finding of default in payment of rent against the tenant.
Again,
So now the tenant is before the court.
tenant, I have denied the tenancy. I have denied the tenancy. My case is like this,
Hmm.
that there is a building. Admitted,
There is a,
there is a building. I am in the first floor of the building since 1990.
and what capacity?
In what
As a
capacity?
owner
I
or
pay
as
the-
a
Yes,
tenant?
yes.
Sorry.
In what capacity? The performer defendant who already expired.
Let him die. This petitioner,
Took the money from me.
Mr. Upadhyay,
Yes.
the petitioner occupied the building and in what capacity? As a owner, as a
Yes.
tenant, as a lessee, as a
In fact,
licensee?
he initially enter into the building with due permission. of the-
Permissive possession.
Yes.
Where is the evidence of permission?
He,
Where is the evidence of permission?
there is no any written, nothing.
No evidence. Oral.
Evidence is there. Evidence,
Where is the oral evidence of permission?
oral evidence, he, the original owner of the building, took the 50,000 from me in 1993. And there was their building, part of the building was vacant, and I occupied it. And thereafter, he could not pay back me that amount, and I continued. In 1994, he demanded the rent. The demand was made from me to pay the rent, and I declined because 50,000 was with me. And I continued to occupy the land. And the big part of the building, first floor of the building, I continue. And here in 2006, the plaintiff respondent purchased the land. And then he filed the suit.
The plaintiff purchased this land,
Purchase.
that land and building.
The building here, that is
Achha, he did not purchase the building. He only purchased the land.
purchased the land.
So how can the building remain floating without the land?
That is my not decided. There are some cases also, the maxim, the attachment means.
Appurtenant.
Building wall, etc. But some court has said, no, it is not.
So the building is a separate
Yes, yes.
entity, land is a separate
Absolutely
entity.
correct. Your lordship is absolutely correct. But I said that my case is there, I have taken the various plea here. Firstly, I have also taken the adverse.
Mr.
Yes.
Upadhyay, to this extent, we can accept it that a purchaser had purchased an encumbered land. So whatever encumbrance was there with the original landowner,
Yes.
he had also purchased the encumbrance also. So your right will remain. We are not on that. We are asking you what right you have.
No, that exactly. so.
See,
Yeah, I have
suppose
taken the
Mr. Upadhyay,
adverse version.
Mr. Upadhyay,
Yes, absolutely correct. I
Suppose-
agree with your lordship. What is my right? I have to
Mr.
serve. What
Upadhyay,
is my right? I have to
Mr.
serve.
Upadhyay.
Yeah.
Suppose today I require Mr. Chaudhary to pay 50,000 rupees to you. Okay. Does it mean he'll have a perpetual right over a part of your property?
No, that is why I have taken the
Mhm.
here. in the-
So
Yeah.
I think the position of the petitioner is this. So his occupation of the land is either permissive
Yeah.
or he's occupying as a implied tenant
Standpoint.
in lieu of the money that he had already given. Suppose
That is the
we
Initial, my lord.
suppose we go a little beyond the law, we also accept implied tenancy. But that tenancy cannot be for in perpetuity. That implied tenancy will also have to be proportionate to the amount of money that was
Yes.
taken.
But
So it will have
Initial
the,
entry,
Uh-huh.
how I enter into the property, that is a initial,
so first you explain us
yes,
in what legitimate manner you entered the property.
right, that is, my lord, that person, that original owner, he took the amount from me. And that was the second, I entered.
That doesn't mean there is a perpetual right in favor of a money lender to occupy somebody else's land. It will be a dangerous proposition.
No, he allowed. That is why I had the initial step that it was a permissive occupy. Because
Where is the permission?
the permission is the oral. There is no tenancy agreement also.
Mr. Upadhyay, suppose even there is no oral agreement also, forget about written. Where is the permission?
The permission, there is no written permission.
We are not on written. We are on any kind of permission.
Any-
Forget about oral. We are also asking you permission by sign also. But where is the permission?
No, that is, I don't say there is no written permission, but it is oral. I have met.
Then how can I pass an order in your favor?
My written
Hmm.
statement there.
The written statement is only a stand you have taken. It is not a material on record. Written statement, you can write anything, whatever you feel like. But you have to prove through
The initial
evidence.
entry, initial entry.
This
in
is
what
a-
capacity I enter in.
This is a post-appellate stage. So now written statement has no value.
No, there are other aspect of the matter.
Show us the material.
So what is the error in the judgment? I shall show.
No. First, you challenge a judgment on the basis of an error that you had a permissive possession.
The
So
initial stage, later no.
Later
I
what?
take the adverse position, that is why I cannot say that it.
later
The
adverse
entire period.
possession, no. Because this man asked you to vacate, there is no adverse possession.
My lord, here the initial stage with permission I enter.
We adjourn it for the day, you think about something which will be legally acceptable. None of your submissions are acceptable.
The other aspect of the matter also,
What other aspect?
here what happened, the Munshi, Lanak Munshi passed the judgment without deciding the issue number 4,
Which issue number 4?
your lord.
Rightly decided the issue number 4.
No, did not decide at all.
You said issue number 4.
Issue number 4, my lord,
Issue number 4 is at page 74.
issue number 4, my lord. Whether-
Page number.
Yes, page number 49. Whether the plaintiff purchased the suit land and the premises from the performer defendant and thus became the owner.
Sorry, whether the plaintiff purchased the suit land and premises.
Yes.
Have you denied it anywhere?
Yeah. No.
Did you deny in
Yes,
your written
yes,
statement that he had not
That is
purchased?
my case. I have
That he had
denied
not
that
purchased?
The building was never purchased by you. CLD does not speak of the,
Where is your statement in the written statement that he had not purchased?
yes.
Mhm.
Lordship. No, it is admitted, he also admitted.
No owner will admit he had not purchased.
Your
Don't tell me that.
lordship, my-
Where is your
29,
stand?
29.
Page number
Page 29.
29. Where is your stand that he had never purchased?
Yes.
Is not the landlord. And
Yes.
this is a general statement.
No, not the general statement, categorical. There are two, that the scheduled deed such and such by which he claimed to have purchased does not speak of the transfer of.
Sorry, where are you reading?
Yes.
Which page you are reading?
29,
29, huh?
29.
29, which paragraph?
Paragraph 2,
2.
2, 3, that is schedule of the deed number such and such does not speak of the transfer of the suit premises, as the land schedule of the deed does not speak the sale of the standing.
No schedule speaks of any transfer.
Schedule is
Schedule is only the identity of a land. Transfer will be mentioned somewhere else in the land deed.
second, not paragraph. The suit premises has got the independent identity and existence. It has one construction document which does not contain the independent configuration money of the sale of the suit premises cannot be treated at a sale of the suit premises by the document as such the deed number is not the instrument of the selling the suit premises for plaintiff. In the suit, the plaintiff has miserably failed to produce any document which especially speak of the selling of the suit premises.
This is a negative averment. It's a negative averment.
Very pertinent question, whether
No defendant can make out his case on the basis of a negative averment, that he could not produce anything, and that too in a written statement.
very pertinent question. How a day, a person purchases a land, there is a multi-story building.
Doesn't matter. We don't find
Whether,
it.
whether they just nearby purchasing the land.
We are do not notice any prima facie case in your favor.
That issue never decided.
Okay.
Issue number 4 was not decided until it is admitted. That was my learned civil judge. He admitted. And he also did not decide. He noted that it was not decided. Page number 80.
Who is the pro forma defendant number 3?
He was the one.
Wife of Madhav Das.
Yes. Madhav Das was the land plaintiff.
No, PW3 had deposed that her husband was the owner of the suit premises. Court had accepted it. This conclusion of the court may not have been under a heading issue number 4, but that conclusion is there. This conclusion answers issue number 5.
He was right. He was right. His lordship has already my written statement. Please.
No, written statement is nothing.
Yeah.
You did not say
Yes.
anything.
Written statement, my lord, my specific case is there. You have not purchased. Plaintiff had not purchased the building. He purchased the land, but he has not purchased it.
PW3, did you cross-examine PW3
Yes.
that you are not the owner, that your husband did not
Yes.
purchase the land? Where is your cross-examination?
Evidence.
Because PW3 had stated that her husband was the owner of the suit premises. Did you cross-examine PW3?
Deputy 3 was.
Where is it?
But that
Let us
I have-
bring it. Mr. Upadhyay, P. Upadhyay and counsel for the petitioner. The orders dated 19/8/2023 of the learned civil judge Kamrup in title appeal 14/2019 and the judgment and decree. And the judgment decree dated 25/3/2019 of the learned Munsif Rungia entitled suit 7/2019, whereby the claim of the petitioner to remain present in the suit premises had been rejected. Mr. Upadhyay has raised the ground that before the trial court, the issue number 4 was whether the plaintiff had purchased the suit land and the premises from the pro forma defendant and thus became the owner thereof. It is the contention of the petitioner that the said issue was not decided at all. And if the issue was not decided, according to petitioner, the suit itself would be not maintainable against the petitioner defendant. In this respect, it is noticed that while deciding the issue number 5, the learned Munsif had taken note that PW3, being the wife of the landowner, had deposed that her husband was the owner of the suit premises and her husband had let out the suit premises on rent to the petitioner. Although the issue number 4 may not have been directly addressed, but if evidence had been rendered by PW3 that her husband was the owner of the premises, the said issue remains impliedly answered. In this respect, it would be relevant to examine the cross-examination made by the petitioner in respect of PW3, whether the deposition that her husband was the owner of the suit premises had been controverted by the petitioner. Mr. Upadhyay seeks for adjournment to provide the relevant evidences for examination of the court based on so and so. If you have cross-examined, we'll take note of it and maybe in your favor.
Yeah.
Item 7.
Mr. Gore, which order is challenged?
Order dated 21/6, page 20,
Page number
25.
25. This is the implement order. You are from the ASTC.
Against this order, appeal may be prepared. Lordship.
There
is a provision for appeal, order 43, rule 1, rule.
But this is under 227.
Lordship.
227, we can look
Yes,
into it.
Lordship, but there is a
Whether the court had properly exercised the jurisdiction, the High Court can look into it.
Lordship,
It's a continuous superintendence.
there is appeal provision.
But is ASTC a state? Is section 50 notice required?
Lordship, ASTC is a state government department. Not
No, it's a state government entity, but is it a state? CBC.
There is a judgment of honorable Supreme Court.
Judgment also. Let us see.
2006.
Against the government or against a public officer in respect of any act. Which paragraph, Mr. Gore?
26, page, para 26.
26. The court does not even look into it, whether they are a government or not. It only says being fallen in the category of state of Assam. Where is the finding? Set aside, go back. Let him determine this issue. Otherwise, we'll issue notice and stay. No one will be benefited. Because the concept of state under Article 12 and the concept of government under Section 80 of the CPC, they are different. It's not one and the same. Under Section 12, it's a wide jurisdiction, instrumentality of state. So, if a state has all pervasive control over any entity, that is also a state. But same meaning cannot be given to word government in Section 80, I think. Is there any judgment on this?
No.
Try to find out. I think I should not pass the order in a rush today itself. Please come prepared on that. This one.
CPC in 2016.
This one.
Yes.
No, here I have read it, but here only says a municipal council is not a public officer.
Yes.
But here is a question. It is not whether they are public officer or not. Question is whether the ASTC is a government or not.
Yes, to that specific judgment is not. In another judgment regarding BSNL, there was a judgment of 2016 one STC, but in that case also it was relating to the limitation, whether limitation is applicable to BSNL.
No, limitation will definitely be applicable to BSNL. That
No,
is not
no, limitation in the context of whether the BSNL can be considered Union of India. In that context, because besides that, no, even
that's a judgment for under Section 80.
Malad.
It's a Section 80 judgment or Section the Article 12 judgment?
Limitation under the limitation.
Will it help you?
Malad, para 11 of this judgment. Page 370, Malad. Page 370. Made it, Malad.
Yes, sir. Supreme Court relies on General Clauses Act.
Malad. But here, Malad, the central government.
Now, what is this? It's a corporation, I think. ASTC, State Transport Corporation. Do you have your articles of association? And
Right now, I don't think.
check out from that whether you can be brought in within the concept of a government. Concept of government, mind you, not Article 12 instrumentality of state. There, yes. We are issuing writ in your favor also against you. Heard Mr. J.C. Gorland, counsel for petitioner, also Mr. R.M. Das, learned counsel appearing for the respondent ASTC. An order dated 21/6/2023 of the learned Munsif Kamrup Metro in TS 131/2020 is assailed in this petition under Article 227 of the Constitution of India, whereby the learned Munsif had declined to pass the judgment in the title suit, inasmuch as an issue had arisen as to whether the respondent Assam State Transport Corporation is a government or a public officer requiring issuance of notice under Section 80 of the CPC. The learned Munsif was of the conclusion that the Assam State Transport Corporation, being in the category of state of Assam, there would be a requirement of a notice under section 80. Section 80 imposes the requirement of a notice in respect of a civil suit against a government or against any public officer. In the circumstance, the issue for determination would be whether the respondent Assam State Corporation is a government or a public officer. And a mere conclusion that it is within the category of state of Assam may not be sufficient for the purpose. Both Mr. J.C. Gore and Mr. R.M. Das praised for an adjournment to examine the matter as to whether the Assam State Transport Corporation under the law, corporates, under the law, can be included in the concept of inverted comma government or public officer under section 80 of the CPC. When do you want? List on. You choose a date. Here you are. We'll dispose it off. As the matter involves determination of a question of law, an endeavor would be made to give a final consideration on the next date of hearing.
Item 8.
Yes, Mr. Das.
We have filed this CRP.
Against which order?
Against the order at page 69, my lord.
69.
Yes, ma'am.
Lordship, I'm appearing on behalf of respondent, Lordship. Lordship, we have no objection against this CRP petition.
Sorry,
We have no objection against this petition, Lordship.
we can allow the petition.
Yes.
Very good.
Lordship, if possible, there may be fixed for final disposal of original.
In our register.
Long pending.
So there's a walkover against you.
Yes, sir.
Change করবে নাকি? তোমার সঙ্গে বলবো। Where is the order dated? 3/3/2023.
My lord, page 69, my lord.
69. Dr. Only second time I was back. Come on. 69.
Yes, my lord. It was 7,
My last page is 68.
68.
This is CRB 344.
My lord, 344.
In my book, the last page is 68. There is no 69. Check up, we'll take up after some time. See, maybe some.
Item 9.
Yes, Mr. Singh.
May please the order. This is civil division petition. I can order dated 15/5/2023. That is that keeping order is at page 46, my.
46.
And by this order, there was substitution petition and the abatement of the petition for setting aside the abatement was pending. And also the this case for condemnation of delay. So
This petitioner is a respondent or a plaintiff?
petitioner is the plaintiff.
Plaintiff. So some defendant died.
One defendant number one
Died. So there's the issue of setting aside abandonment and substitution.
Yes.
And then what happened?
This petition was dismissed on the count that the condemnation petition was filed. In fact, the condemnation petition was very much there, but it was dismissed for default a previous day. That is 28/2/2023. I have challenged that order also. My lord, what happened? Why it was?
So you should have been given an opportunity to revive that petition.
Yes, my lord. And why it was dismissed, my lord? Dismissed for default because I have not filed a separate separate Hazira in that miscase.
In
Otherwise,
which
we-
case?
In miscase number 288, that is was 288 of 2019.
For condoning the delay.
Condoning the delay.
You did not file Hazira.
Only did not file Hazira in the miscase. Otherwise, I was all.
So miscase was listed the earlier day and the other two miscases on the next day.
No, miscase and this petitions were also listed on the same day.
Same day,
Same
okay.
day along with the title suit matter.
Huh.
So The petitioner
So,
used to
so-
file Hajira only in the main suit, my lord. That is title suit,
And not in the miss case.
not in the miscase. May I read the order?
Understand. What to do?
That's why, my lord, I have challenged both the order, my lord. It's a very technical, hyper technical.
Understood. You serve Dusty on this
Yes.
defendant come. If I stay, it will remain there for 5 years.
Yes, my lord. Only notice.
You may also
only
suffer, the
notice
other
may
side
be-
may also suffer.
Only notice may be.
But suit will keep on proceeding.
When this civil division petition will be pending, the learned civil judge may not proceed.
No, we don't believe in that. We don't believe in that indirect method
Yes,
of
yes.
staying a suit. Best, why don't you serve the defendant? It is from which place? Kamrup Metro. It's here only.
No, the defendant is at
No, no.
Guwahati itself, man. Defendant number
They are
one.
appearing.
They were not appearing because Ranjit Chatterjee died. So legal heir Srimati Babli Chatterjee and Ratim Chatterjee. Until and unless they are impleaded, my lord, they are substituted, then only we can serve the notice, my lord. My lord.
Ranjit Chatterjee died.
Rajat Chatterjee died.
And this is a stage where after his death, some applications were filed and some notice is yet to be issued.
Notice is yet to be issued upon the subject.
Understand? So there is no question of any other side appearing.
Yes, ma'am. There are other two defendants also, my lord.
No, they are not concerned.
Yeah.
This suit will abate only against Ranjit Chatterjee, not against the others. Where is your petition seeking convocation of delay?
Yes, father. It is at page 26, my lord.
26. It's numbered.
It is numbered, miss case number 288.
It's numbered.
Paragraph 26. Page 26. And actually.
Heard Mr. B.K. Singh, learned counsel for the petitioner. The petitioner plaintiff instituted the title suit 1618 against, amongst others, the deceased Ranjit Chatterjee, who was.
There is one correction. Actually, it is mentioned in the order sheet. It is Ranjit Chatterjee. It is actually Rajat Chatterjee.
Against
Rajat.
one Rajat Chatterjee, who was arraigned as the defendant number 3.
Defendant number 1.
Rajat Chatterjee 1. No, okay, or as defendant number 1. It is stated that during the pendency of the title suit, Rajat Chatterjee died on 12/12/2018. On his death, as applications for substitution were not instituted within the prescribed time limit, the suit had abated against defendant number 1, Rajat Chatterjee. In this circumstance, the petitioner plaintiff subsequently files petition for substitution comma, setting aside of abatement, comma, as well as for condoning the delay in filing the two applications. The petitioner instituted miscase, what's page number 26, right? Instituted miscase 288/2019 under section 5 of the Limitation Act 1963 for condoning the delay in preferring the accompanying petitions under Order 22 Rule 4, read with section 151 of the CPC. The applications came up for the application for substitution of the legal heirs came up for, which was numbered as?
That substitution petition was petition number 1233 of 2019.
Which is numbered as petition
233 of
1233 2019 came up for its consideration before the learned civil judge number 3 Kamrup Metro. And accordingly, the order dated 15/5/2023 was passed. By the order dated 15/5/2023, the application for substitution was held to be barred by limitation and accordingly dismissed, by arriving at a conclusion that no petition for condoning the delay under section 5 of the Limitation Act had been filed by the petitioner. But it is noticed from the annexure to page 26 of the present petition that miscase 288/2019 had been instituted by the petitioner under section 5 of the Limitation Act for condoning the delay. Accordingly, it appears that there is an error of fact recorded by the learned trial court that no application for condoning the delay had been instituted by the petitioner. As the order dated 15/5/2023 is passed, rejecting the application for substitution solely on the ground that no application for condoning the delay had been preferred, whereas on the other hand, the record reveals that miscase 288/2019 had been instituted for condoning the delay. We are of the view that on facts, the order dated 15/5/2023 is not maintainable. Accordingly, the order dated 15/5/2023 is set aside and the matter remanded back to the learned civil judge number 3 Kamrup Metro to take note of miscase 288/2019 filed by the petitioner plaintiff for condoning the delay and pass appropriate orders in the said miscase 288/2019 as well as the other petitions filed by the petitioner for substitution of the legal heirs as well as setting aside the abatement as may be advisable under the law.
Highly obliged.
Revision allowed as indicated. Mr. Das, I always follow, once the matter is gone, it will be called again at the end of the second round. Normally, I don't deviate from that. You have to bear with it. Yes. Am I audible now?
Look, yes.
Yes, yes.
Yes, the Indian order is a page 12, Lordship. State Bank of India, Lordship, filed a money suit for recovery of loan. Here I am the defendant. We filed the application before the court below seeking time for time for filing WS as well as Wakalatnama. That was rejected and suit proceeded directly.
Defendant is absent. By petition number Khatoni again sought for adjournment. The defendant is absent, that is petitioner here.
Petitioner was absent.
Who is the second line, please read, second paragraph?
It
It
is
is
seen
seen
that
that on earlier occasion also the petitioner counsel.
council was asked to submit his
So who is the petitioner counsel?
lordship, the council before the court below.
Counsel for the court below.
Petitioner council. Actually, the petitioner,
No, no,
This order is-
what does the expression?
yes,
The
the order is
petitioner
wrong.
counsel was asked. Who is he?
Actually, the order is wrong, lordship.
I think it should be the counsel for the defendant, I
defendant,
think.
defendant. In fact, petition numbers are different. Typographical error on the part of the learned court.
Which is the provision for filing written statement, the time limit?
Order 8, rule 1.
Order 8, rule 1. Mr. Bora,
Lordship.
what is the position of law? Suppose you don't file written statement.
Yes.
The suit will proceed in the absence of written statement, or it will proceed ex parte?
Lordship, it will proceed ex parte in the absence of a written.
Ex parte, or
Yes.
it will suit will proceed minus the written statement. Which one is right? Hmm. Here it says the suit will proceed ex parte in the present situation. Why? Because this behavior should not be encouraged.
Yes.
Will the suit proceed ex parte, or the suit will proceed without the written statement of the defendant?
As per this.
There are two different implications, mind you.
Yes.
Once it proceeds ex parte means the defendant cannot participate in the proceeding anymore.
Yes.
If it proceeds minus the written statement, that means whatever evidence is brought forth by the plaintiff
We can proceed.
can be cross-examined and
Yeah.
by the defendant. Which is the correct position of law?
Here, lordship, the entire suit is directed to be expert.
I know here, which is the correct position of law?
The second one, lordship. In absence of written statement. we can be-
From where do you say? Hmm.
I'm not clear.
I think there is a Supreme Court judgment on this checkup. Most likely it is there.
In fact, after this, an order 7 application was also filed by the,
Sorry,
after this, an order 7 rule 11 application was filed by.
what
the
is Order 7, Rule
the
11?
Rejection of plaint. Rejection of plaint application was filed.
You have filed that the
Yes.
plaint should be
Yes,
rejected.
yes. That is pending for objection hearing. And on last occasion, the respondent bank,
Suppose you are depart from filing written statement, can
Yes.
you file petition under Order 7, Rule 11?
in my.
That will be
responsibility-
basically
Yes, in,
an indirect method of filing written statement. Can it be allowed?
since it's a separate issue of maintainability.
Understand?
Yes,
Once you file a written statement, thereafter you can file Order 7 Rule 11 petition that the plain should be rejected. Or you may file it also before filing the written statement also. It is your prerogative. But once you are debarred from filing written statement, can you do it?
but that.
Because that will be an indirect method of allowing you to file a written statement. Is it permissible? I don't think so.
Order 7 has already been admitted by the learned court.
State Bank.
Yes.
Or which branch?
Amtren branch.
Amren.
Hotel.
You go and serve Dusty on the State Bank.
Yes.
We are allowing you today.
Sure.
Maybe on the next state, we'll think about some orders.
Okay.
Heard Mr. R. Bora, learned counsel for the petitioner. An order dated 5/7/2023 of the learned civil judge West Karbi Anglang Hamren in MS 01/2023 is assailed in this petition. By the order of 5/7/2023, upon repeated adjournments being sought for, the defendants were disallowed to file their written statement in view of the provisions of Order 8, Rule 1 of the CPC. But it is noticed that by the order of 5/7/2023, it was also provided that the suit will proceed ex parte against the defendants. A question would arise as to whether in the absence of written statement being filed, a suit would proceed ex parte against the defendant, or the suit would proceed in the absence of the written statement of the defendant. In view of the above, notice be issued to the respondent State Bank of India, and the petitioner is also, and apart from effecting service by registered post method, the petitioner is also allowed to serve Dusty on the respondent State Bank. Further consideration would be made upon service of notice on the respondent State Bank till the next returnable date. Further proceeding in MS 01/2023 before the learned civil judge West Karbi Anglang Hamren shall remain state.
Item number 11 is also on the same set of facts, but the case number is different. And the defendant is different.
Same. Order is also same.
Yes. Case number would be different and the defendant.
So I can take your word without looking at it.
No.
Same order. Money suit to be recorded.
What details need?
Take a fixed date. 2 weeks. You're listing after 2 weeks, you go and serve Dusty on them.
22nd November. Item 12.
Mr. Bora, what is the amount in the money suit?
In one case, money suit number 01, 5,86,000.
5,86,000. 86,000.
And money suit number 02, 14,82,000.
14 lakhs.
Yes.
And on which date notice was issued in the money suit?
On 4/2.
4/2.
On 17/12/22.
17/12/2022.
Yes.
So you should file your written statement within 3 months.
Yes.
So that will be 17/3/2023.
Three.
And on which date this order was passed?
On 5/7.
5/7.
Yes.
So there is a delay of
4 more months.
4 more months.
Yes.
For 5 lakhs, if the interest is, how much is the interest?
They have claimed.
Not they have claimed. Normally, what is the interest?
Normally, 6%, I think.
6%. No,
There are three different loan.
Mr. I'll be very happy to take a loan at 6%
No,
if we
it's-
can,
one
if
is-
we can arrange for
One
it.
is 16.65 per annum.
Must
and
be
one
something
is
more.
8.5.
Let us take it to be 12%.
Yes,
So 5 lakhs, 12% is,
60,000.
Huh?
60,000.
12% is 60,000. And for per month, it will be 5,000. 5,000.
5,000.
For 4 months, it will be
Five for
20,000.
20.
Be ready to pay cost of 20,000. You will
But
get the
there
order.
is another thing, Lordship.
Nothing more.
On 2 occasions, we filed an application stating that the list of documents which the plaintiff bank is relying upon, those documents have not
No.
been served. And that,
Then you should have come
yes,
by filing revision for non-consideration of that petition.
yes.
We cannot take note of that now. Be ready to pay the delay cost, we'll allow it.
Lordship.
Okay?
Item
And
12.
serve the bank and come back. Yes, Mr. Islam.
First to hear lordship, Elector 6 page 37 is the implement lordship.
Page 37.
Regulation authority.
The relevant petition will be lordship is 40.
Hmm.
The lordship my one petition lordship. To the extent that lordship.
Amendment of judgment and decree.
Yes, lordship. And some relief, specific relief lordship.
Just a minute. Amendment of judgment and decree. Section 152.
152.
And specific relief act.
28. Lordship.
3. But both cannot go together. A petition under 152 and a petition under 28(3) of the Specific Relief Act, both cannot be in the same petition.
Something is different lordship.
Not sometime, always. They can never be together. Because 28(3) is if the purchaser lessee pays the purchase money or other sum which is ordered to pay under the decree, on application may say award the purchaser lessee such further relief as he may be entitled to. So this means you accept the judgment and decree. After accepting whatever you have to pay, you pay it.
Yes.
After payment, some further relief can be given to you. That is 28(3).
Yes.
152 is arithmetical or correction of other error in the judgment which happened by omission. Both are two different. It can never be simultaneous.
Because the prior lordship, what the prior the petition lordship, actually it was lordship, it was made in the petition lordship, in the petition.
First one is you are accepting your judgment. You have complied with the judgment, paid the required amount, and thereafter some further relief. Another one is you want a correction in the judgment. How can you say yes on one hand and no on the other hand in the same petition?
Judgment amount lordship.
So,
Earlier lordship.
so Mr. A defective petition is bound to result in a defective order.
First petition lordship,
Any defective petition is bound to result in a defective order. How do you expect a revision court to now correct it? Use the most common sense.
Yes.
Don't have to rely on any law also. On one hand, law says whatever is required to be paid, I have paid it. I want some further relief. That is 28(3). 152 is I want a correction in the judgment. Both can never.
In this lordship, because the prior lordship, it was lordship, the amount also paid earlier. Prior was also their lordship. But the relief, that was not lordship.
The both cannot be
Yes.
together, Mr.
But my understanding was
We
the relief was
do.
left out by clerical mistake lordship. This relief was left out. Lordship.
So,
No,
how,
pura for this
so,
month.
so what is wrong in this order then?
This month for.
In particular, mentioned the power under 52 contemplates correction of mistake. It does not empower the court to have second thought over the matter. Furthermore, 23, that if the purchaser deposits the purchaser which may on application may say award the such further relief. In the instant case, there was specific for delivery of possession, but my lawyer, after taking consideration, had not granted the said prayer. So, once, right, he said once 152 is not applicable, 28(3) is also not applicable. He's absolutely right.
The court said that the relief was not granted. Actually, lordship, our top lordship, the relief maybe lordship left out lordship. Because the court
No.
decreed lordship. So,
See, whenever court passes an order,
Yes.
it is always by implication that whatever is not provided in the order has been rejected. 152 is an exception. 152, firstly, it is arithmetical error. Suppose 2 plus 2 is 4, but the court writes it to be 5 or 3. Then it can be corrected, 152. Or else, accidental slip or omission. So accidental slip of omission and the implied rejection are both in conflict. So you will have to prove with some further material that it was a accidental slip.
I want
Either you say
that must is yes.
that during the deliberation, the court expressed a view that this will be granted. But while dictating the judgment, court forgotten about it. 152 is
Yes,
applicable.
maybe that lordship, because the relief what I have lordship entitled lordship that was granted lordship. Purely it is decreed lordship, but only the delivery of possession. This must maybe the
Court may not have given, you go in appeal.
that is lordship may not have given because otherwise
No, you go in appeal.
only that point only they cannot be rejected. Or if otherwise
Sorry,
will be rejected.
we cannot accept that. Moment we open this floodgate, tomorrow every matter will come like this, that the court had omitted to give this relief to me. So now we open up the matter once again.
Right.
Suppose today I pass a judgment against me, you file another 152 tomorrow. That is, on one hand, I'll reject your prayer. You say that it was accidentally, it was not given. Where is the end of this proceeding? Go in appeal. We'll give you liberty to file appeal.
Lordship, then delay part maybe the
We cannot condone.
that part
We'll only
maybe
give you liberty. You argue before the other court where you will file.
that some maybe kindly accept. Otherwise,
We
lordship,
cannot.
Otherwise, lordship, he got the benefit lordship, but now
Understand,
it becomes the-
no court can condone a delay in respect of proceeding which will be in future instituted in another court. Preemptive condonation is not available. Read Section 5 Limitation Act. That provision is not there. But we can word the order in such a good way that you may ultimately get the benefit. But we cannot condone it beforehand.
some observation given lordship, then I'll get the benefit.
That we can
That
say
was
under
the-
this circumstance it has.
Later can be taken lordship in
We can do that.
Yes, sir.
So the third,
Yes, sir.
as learned counsel for the petitioner. Where is the petition 143/2022?
Petition lordship,
Page number,
page 33 lordship.
page 33. Where is the judgment of the court?
The court lordship page
Hmm.
17 lordship.
Where is your plaint?
Page lordship page 13 lordship. Contempt.
No. Now, what order do you want?
I want lordship that amendment will be allowed lordship.
Uh,
Because lordship in plain lordship, my prayer is specific prayer was there. That left.
no, it's not the amendment of judgment.
I try to lordship whether if there is this situation will come under the purview of section 152 lordship.
But I still feel that it's a case of appeal because you see your prayer number 2
Yes, sir.
for recovery of page 15, recovery of possession.
Yes, sir.
This prayer was not considered at all.
Yes.
So it may not be a case for amendment of judgment. It will be a case of setting aside the it will be a case of remand the matter back to the court to also take note of prayer number 2. This is number 1. And number 2, if you come to that, where is the judgment? If you come to the judgment, You come to page 25. In the light of it, I find a plaintiff being ready and willing to perform his part of the contract. You have already performed because the entire money was paid. So there is no question of ready to perform his. So this finding is also wrong. So if this finding is wrong, the finding ought to have been had already done his part of the act, and the only part of the act of the defendant remains to be performed, that is executing the sale deed. So that should also include the prayer number 2 to hand over possession. But what will you do now? This is under 227.
Yes.
I
remember, Lordship, there is the.
Sorry.
This Lordship, in terms of judgment, Lordship, I am not clear about the judgment, Lordship. The court says, Lordship, the second part, the recovery of possession, which is Lordship, the subsequent.
Understand.
Yes.
We are in your favor. Only
Yes.
thing you have created a mess by going for 152. We should have gone straight away for appeal. And the power of the appeal court is always much larger and wider. Many things can be done in an appeal. But these 152 and 23, they are restricted powers. Why did you invoke 152 unnecessary? Now I don't think I can convert this petition to an appeal now. What to do?
Review, Lordship.
It's your own legal complication you have
Yes,
made.
Lordship.
Hmm. What to do?
Whether review can be, Lordship, will be reviewed, Lordship.
You could have filed a review.
Yes, it will be review. Lordship.
You could have easily filed a review. You could have gone for appeal. Because firstly, that conclusion is wrong, requiring you to do your part.
Yes.
Because court had already taken note of that you have already done your part. You have paid the complete amount. What remains is execute the sale deed. And delivery of possession is a consequence of execution of sale deed.
Yes.
But again, you have to serve notice on that man. Heard Mr. Huh? Okay. Heard Mr. S. Hockland, counsel for the petitioner. The petitioner plaintiff instituted PS 8/2012 in the court of the Musif number 1, Gwalpara, amongst other, with the following prayers, page 15, A or B to DTO. To support the prayer number A for a direction to execute and register the registered sale deed, the petitioner relies upon the fact that the entire sale consideration pursuant to the agreement to sale had been paid by the petitioner. And accordingly, it was a case for specific performance by the defendant for execution of the registered sale deed as a consequence of such agreement to sale and further consequence of the entire amount having been paid. The learned trial court in its judgment dated what is the date of the judgment? The judgment dated 31/3/2015 had taken note of the execution of the agreement to sale as well as the payment of the entire sale consideration by the petitioner. But however, in para 33 of the judgment had recorded that the plaintiff being ready and willing to perform his part of the contract is entitled to specific relief of the agreement for sale. That is for a direction to execute the sale deed. It is noticed that the conclusion of the learned trial court in its judgment that a petitioner is ready and willing to perform his part of the contract is inconsistent with the factual situation that the petitioner had already paid the entire sale consideration. And what remains is for a direction to execute the consequential sale deed. Delivery of possession is consequential to the registration of a sale deed. If otherwise, the sale is complete and valid in all respect. But from such point of view, the second prayer, that is prayer B of the petitioner plaintiff for a decree of recovery of possession of the scheduled property had not been granted by the learned trial court. In the circumstance, the petitioner instituted petition number 143/2022 under section 152, read with section 28(3) 152 of the CPC, read with 28(3) of the Specific Relief Act. Amongst others, section 152 of the CPC is for correction by the court of its own judgment as regard to any accidental slip or omission in the judgment that may have been passed. Whereas section 28(3) of the Specific Relief Act is for that if the purchaser or lessee pays the purchase money or other sum which is ordered to pay under the decree within the period referred, the purchaser or lessee would be entitled to any further relief, may be considered for any further relief as he may be entitled to. From such point of view, we do not notice any gross irregularity in the petitioner filing the application under section 152 CPC, read with section 28(3) of the Specific Relief Act, inasmuch as, firstly, the trial court had omitted to notice that a petitioner had already paid the entire sale consideration, meaning thereby that the conclusion that the petitioner plaintiff is ready and willing to perform his part is inconsistent and redundant with the factual situation. Hence, prima facie, it appears that there was a case of omission by the learned court in its judgment. Secondly, if the petitioner had paid the entire sale consideration, we see no reason as to why an application under section 23(8)(3) of the Specific Relief Act would not be maintainable for further relief of delivery of possession, which in fact is the prayer B in the suit itself, which again also cannot be a matter where the petitioner would not be entitled to the further relief based upon the omission as noticed earlier. In the circumstance, issue notice to the respondent, returnable on so and so. States were registered post 3 days. Petition also allowed to effect the stay on the respondent. Upon appearance of the respondent, a further consideration would be made on the maintainability and acceptability of the order dated 22/3 of the order dated 22/3/2023 passed by the learned Munshi number 1 Golpara in the application in the petition number 143/2022 of the petitioner plaintiff. This constituency. No point in staying also. What to stay? It is refused. How will it be executed? He is bound to make a sale deed in your favor, but there is no order to hand over possession. What kind of execution will he make?
Item
think
13.
you need a more positive order in your favor. That will pass only in his presence, not in absence. Yes, Mr. Sheikh.
Is your lord. My lord, your lordship would be pleased to turn to page 54. This is the impugn order. I filed a
Page number.
petition for amendment, my lord.
Page
It is
number?
54.
54.
Amendment petition was not at all.
Amendment petition was rejected.
Was rejected.
What do we do? Issue notice, stay the proceeding.
Okay.
Today we cannot do anything else.
Notice my goal, my lord. Further.
And what is wrong with this order?
My lord,
Unless the court is told
my lord,
how and in what manner the original pleading originally submitted is proposed to be amended, court cannot effectively exercise to permit.
my lord,
What kind of amendment you
yes,
want?
my lord, I have taken more than 1 point. The learned court below, my lord, consider only 1 point, that it will change the nature and character of it.
No, come to page 57.
My lord,
Read that last 7 lines.
yes, my lord, 57.
Unless and until.
Unless and until the court is told,
Told in what manner
until
is
the
proposed
court
to
is
be
told
amended.
how and what manner.
Huh.
That is a point, my lord.
What
Mr.
manner the pleading originally submitted by
Mr.
the
Sheikh.
court is proposed to be amended.
Mr. Sheikh,
Madam.
suppose today you file a petition for amendment before this court.
Madam.
Unless I know what you want to amend, I cannot allow it.
I
So
have-
where is your amendment petition?
My lord, yes. my
Which
lord.
page? Let
Your
us see
lordship
whether you
can't
have
do-
stated or not.
Can't do this. My lord, this is a very wrong finding, my lord.
Let us see your amendment
Yes,
petition.
yes. I will give you.
Mhm.
Page 35. but
35, where you have stated what you want to amend,
Yes,
which page?
I'll give you.
Page 35 is on affidavit.
4, my lord.
Uh,
Page 36, my lord.
36,
Yes.
application for amendment.
4. Page 39.
39. Heard Mr. Rameshek and counsel for the petitioner also. By this revision petition, the petitioner assails the order dated 21/9/2023 of the learned Munsif number 2 Nalbari in TS 79/2018 in respect of petition number 258/2021 under order of 6 Rule 17 read with section 151 of the CPC. The petition of the petitioner for amendment of the plaint or written statement
Written state.
of the written statement had been rejected by the order dated 21/9/2023 by providing that one inverted comma DDO, until and unless the court is told how and in what manner the pleadings originally submitted to the court is proposed to be amended, the court cannot effectively exercise its power to permit amendment. ... Court process. Upon perusal of the application under section 6 Rule 17 read with section 51 of the CPC, in paragraph 4 thereof, it is noticed that the petitioner had specifically mentioned as to what is sought to be amended. As specific amendment had been made in the application under section 6 Rule 17 of the CPC as to what is sought to be amended. The conclusion of the learned Munsif or civil court, learned Munsif number 2 Nalbari appears to be contrary to the contents of the petition of the petitioner under order 6 Rule 17 in view of the prima facie case made out. Further proceeding in title suit 79/2018 shall remain stayed. Notice 6 weeks. Steps were raised to post 3 weeks.
Much of it.
Item 14.
Yes, which order, Mr.
Yes,
Doctor?
At page 116,
116.
we filed an application for rejection of claim. That application was rejected by an impugn order, which is before the committee.
Rejection of why it is incorrect? Why the order is incorrect?
The plaintiff filed a suit against a society. The plaintiff is a school managing committee. Now, this school is managed by
It's a government school or private school?
no private school,
Private school.
CBSE affiliation.
Ah.
The school is managed by a society. Now, this SMC is constituted under the control of the society. SMC has no any independent, indefeasible rights by its own to institute a suit. It's unregistered, admitted. So that
Such as
yes,
a school belongs to some society.
society,
Society constituted one school managing committee.
absolutely.
And the suit is instituted by the school managing committee.
So that SMC, yes. Now, our contention before the trial court is
That this suit is not maintainable.
maintainable on the in view
And
of the fact,
and what is the reasoning of the
Lord,
court?
find page 125,
What?
the finding.
Fine.
The other part is the discussion of the submission of the 120. Last part.
And where is the plaint?
Plaint at page 23. One legal
And
argument.
how plaintiff number 1 is described?
Plaintiff number 1
Right.
is described as school managing committee. Plaintiff number 2 is the president of the SMC, and 3 is the principal.
And the relief sought for is?
Relief sort is very omnibus prayer, saying that prayer is, Lord, you will find at page 37. Relief in a form of perpetuity, but fact remains this SMC is only for a period of 3 years. That prayer is also barred under section 34 of the
Just a
Specific Relief Act.
Where is the constitution of the SMC?
Constitution that was not filed by them in the trial.
No, no,
court.
you must be having it.
No, Lordship, I may please.
Because
one,
the
if you-
defendants appears to be part of the
Yes.
society.
No, Lordship, I may allow to place before your Lordship one letter of the CBSE saying that SMC is under the control and supervision of the society as per the CBSE bylaws. Lordship, kindly come to clause 3 of the rules. Page 3.
No, no, Mr. Doctor, what we are trying to ask you is, you are trying to make out a case that only the society could have instituted this suit
Yes, absolutely.
and not the SMC.
The Lordship will find the
And
answer.
I understand.
The query of
So
the-
now we want to look
Yes,
by which document the SMC was constituted and by
absolutely.
whom it was
I
constituted.
understand the query of this.
Ah.
Lordship will find by these rules only. The
No, no, instead
CBSE
of
rules.
giving an indirect reply, why don't you produce the document by which?
No, the CBSE, there is a specific rule how a SMC is to be constituted.
uh,
Lordship will find at page 3 of this my
Hmm.
I played. Clause 20. The school managing committee is constitution, power and function.
hmm.
That is under the CBSE rule section. Here, how is constituted, how is represented by the parent.
Yes, which one?
Lordship will find school other than the government school affiliated with the board shall have a school managing committee such and such.
Constituted as per
Yes,
the act.
is this 2A to this. And the detail, they have details, and the how is represented by the parents, teachers.
No, still the answer is not coming. Who will constitute it?
Their society will constitute.
Ah,
Lordship will
so-
find
so-
the answer is three. Three.
Uh,
The term of the member of the managing committee shall be 3 years. Such and such.
I understand.
Yes,
Mr.
Lord.
Doctor, we understand everything.
Lord.
But to accept your core submission that this school managing committee has no jurisdiction to institute a suit. For that purpose, we want to look at to who is this entity, school managing committee, and who had constituted them.
That itself they have described in the plain para 2 and 3.
They have said that they're only the managing committee, nothing beyond
no.
that.
Lordship will find para 1, 2, and 3. In the plain they themselves described.
And if you see this plain,
No.
this plain appears to be very innocuous. They say, declaration that plaintiff number 1, represented by plaintiff, are legally authorized to manage the affairs of the school.
Yes.
So if you ordinarily understand, a school managing committee will definitely have a right to manage a school.
No, Lordship. That is
This is why we want to know who constituted them, how they were constituted.
that is as per the CBSE rule.
It may be as per, but who?
The society.
Where is that document?
That is in the
Page
plain
number?
itself.
We'll come back at 2 o'clock, you find out, but which
I
page number?
understand the query of it.
So
And
had the school seeking some relief against some other person, then there is a relevance of your submission that they are not authorized to file this suit, but it is the society who can file. But their prayer is, first prayer,
My contention, your lordship, after
I know,
I'll come back.
contention will come later on, first
No, no.
facts.
The basic question lordship has asked.
But their prayer is that declaration that we have a right to manage the school.
Lord,
So suppose today the constitution provides for delegation of the power of a high court judge. Suppose it provides for, it is not there, we know.
no.
And I, by a appropriate order, delegated to Mr. Bhaskar Datta, Cedar Council,
Lord.
that you decide this matter. Once I delegate this power to
Yeah,
Mr.
it is the
Datta,
power.
it will be Mr. Datta who can do it.
Yes, absolutely. correct.
And if Mr. Datta comes forward before any other forum, that give a declaration of my right to decide this matter because I have been delegated,
Yes.
which is constitutionally permissible,
Yes.
then you have a locus to file that petition.
Yes. I understand.
But on the other hand, if this is a civil claim against some other person, and this claim can be made only by the persons who are in the ownership of that particular property or entity or whatever it is, then the question may come that a school managing committee cannot come because the original right.
That is our case, sir. Lordship.
We
That is
understand.
That is our.
We understood your case,
Yes.
and after understanding, we are asking you. this
Yes,
question.
yes.
No difficulty in understanding.
Right.
You can be rest assured. But this is a case of the first type, that Mr. Datta had been delegated the power and Datta comes for a declaration, give me the right to decide it. So this society had been entrusted with the management and they have come that declare our right to manage. So from that point of view, their suit is maintainable.
Okay.
Understood?
I will come back. To your
Yeah,
lordship.
we want some
We'll
answers.
interact.
We want some answers on this
Yeah,
issue.
we'll interact.
Again, for repetition's sake, although it's almost 110 now.
Yeah.
If Mr. Datta's claim would have been against Mr. Decca, that Mr. Decca owes 10,000 to me, then Mr. Decca can take a plea that Mr. Datta doesn't have the ownership of this 10,000 because he's only a managing committee. The original owner is somebody else. I'll give it to them,
Yes.
but not to Mr. Datta.
Yes.
This is the nature of your objection in this case.
Yes, Lord.
But Mr. Datta doesn't come for the 10,000 rupees from Mr. Decca.
Yes.
Mr. Datta says, declare my rights to manage.
Yes.
In a circumstance where Mr. Datta had already been entrusted with the right to
Yes.
manage.
Yes.
There's a difference.
Yes. Lord, you will come.
So we want to see in what manner
Yes.
this society was entrusted the management.
Law points also.
Huh.
Lord,
And
you
if
will kindly
the
consider
society
that-
was
that-
entrusted the management, they have a right to seek a declaration.
I
There's
will all
no
be
reason
to
why the
withdraw
suit is
this
unmaintainable.
Always bow down.
This is the fine difference between what you are submitting and what we want to know.
We will come to that. Lord. We'll take the, in nutshell, the fact.
But Constitution, be prepared with it.
Oh, yeah.
Get it through email, scan, copy
Lord.
email from your. No, why we are asking you this question, you know? Suppose we take the example of a power of attorney holder. Okay. Power of attorney holder seeks some entitlement from a third person. I am the original, you are the power holder. On the basis of my power, this attorney, you are seeking something from Mr. Decca.
That can be done.
That can be done.
Yes. But here,
Just a minute. That is not the issue. It can be done. So had it been done, this suit is maintainable
Actually,
because
yes.
power of attorney holder claiming something for third person.
Maintenance.
Okay. Now, if the power of attorney holder files a suit against me, I am the person who gave the power of attorney. That
is power assortment.
that you are restraining me, although you have given me the power of attorney, but you are restraining me from doing needful under the power of attorney. That suit is maintainable. It is maintainable suit. The power of attorney holder,
Revoke the power of attorney.
you have the option to revoke the power of attorney, no doubt, but upon giving the power of attorney, you cannot restrain the attorney holder from performing his work.
It is prescribed in the.
So in that case, power of attorney holder can file a suit. It will be maintainable.
Correct.
To us, it appears in this case, the SMC is trying to establish their right to carry on the management of the school
Not.
against the persons who belong to that society, who had made them the society.
Lordship is absolutely correct.
I think in this case, the suit is maintainable.
That's it. But here the factual aspect is something little bit different.
In what
Here-
manner it
here
is different?
The defendant number 1 and 2,
Uh,
they have impleaded as an individual entity.
but they are part of the society.
No.
Once you lift the veil, they are a part of the society.
Now this defendant number 1 and 2, their impact, your lordship, is the president and secretary of the society. Now society has been impleaded as a pro forma defendant, has not
Does-
claimed against any reliance.
Doesn't matter. This is a totally different issue. So the managing committee is now in the
Help
same
of the-
status as that of the attorney holder of my example.
Yes.
They are trying to establish their legal right against a society who had made them the managing committee, but are restricting them from performing their duty.
That is not the subject matter of the suit, your lordship. The subject matter of the
No,
suit is.
I'm on the prayer. Look at the prayer.
That I understand.
Look at the
lordship
prayer.
is absolutely correct.
Prayer is allow us to manage the
Yes.
school.
But thereafter, lordship will find the.
So
other
from
things
this
also.
point of view,
Yes. lordship
why
is-
should we arrive at any kind of conclusion that this suit is not maintainable?
There is a part, your lordship.
Please submit. Now,
Lordship is
once
barred
the-
by section 6, is the law, because if the plaint is, I'm asking for a rejection of a plaint, your lordship, it has to be barred by law. Not we to go not, your honor, devolve upon any factual aspect. Now, section 6 of the Registration, Society Registration Act, that bars the suit that unless a committee is registered under the Society Registration Act, that they having a no independent power to. file a
against
suit.
the Registration Society Act.
Yes, yes, your lordship. These are number 1. Number 2, lordship also kind
No,
of.
let us go one by one. Moment to mix up, your thought process also gets mixed up. Let's go number 1. Yes.
Section 6, your lordship.
Suits by and against society. Every society registered under this act
Registered.
may sue or be sued in the name of the president,
Yeah.
chairman, or principal secretary or trustees, as shall be determined by the rules of the society, and in default of such determination, in the name of such person, as shall be appointed by the governing body, for the provided that it shall be competent. So your case is that this is a defective plaint,
Absolutely, your lordship.
are not on locus standi.
No, locus and
Locus standi, we are not accepting it.
No, and supposedly, your lordship, a unregistered society is file a suit. Now, we have to look into it that whether that is in a representative to naturally, an unregistered society by a secretary or president file a suit, that is in representative capacity. Now, if a suit is filed under a representative capacity.
By whom?
By the secretary or president of a organization.
Here, the suit is against the society
Now, that's I understand. But my contention is,
by a managing committee. So managing committee is not a society.
no,
So the requirement of being registered under the Societies Act is not applicable to the managing committee, but it will be applicable to be defendants.
Yes,
Who are the
absolutely correct.
society?
So therefore,
So how can the defendants now say reject the claim because this is a suit by a unregistered managing committee?
therefore, our contention was,
Managing committee is not a
No.
society.
our contention was, in that eventuality, Your Lordship, Order 1, Rule 8 of the Civil Procedural Code will be applicable. And a leave is,
Let us read what is Order 1 Rule 8.
then the leave is required. It's
No,
a mandatory
just a minute. Let us
Lord.
read what is it. Order 1 Rule
Rule
8. One person may sue or defend on behalf of all in the same interest.
Yeah, the SMC is a body who having an interest to, Your Lordship, to defend their interest against the society or some individual. So therefore, all the members of the society is not a major party. So therefore, only two persons in the capacity.
It can be done in a representative.
Yes.
It is
Now,
good enough.
Lordship, there is a requirement that under order 1 Rule 8 requirement is.
What is which requirement?
There's a leave is required.
Where? Which one?
Lordship. 2. The court shall, in every case where a permission or direction is given under subject that the plaintiff expense, give notice of the institution of the suit to all persons so interested. Now, judicial pronouncement says, Your Lordship, that a leave.
So
prior leave is
now,
required.
just a minute. Let us read 181. Where there are numerous persons having the same interest in one suit. This doesn't depend whether plaintiff
No,
or defendant, any
one
person.
More of such person. with the
One
permission
or
of the court.
more of such person may, with the permission of the court, sue or be sued
Yes,
or may
permission is
defend.
required.
Permission is required.
Yes, that permission was not, neither a leave application was filed, nor the learned trial court touches that point also. We may specifically urge that point, that this suit is read for.
Where is that conclusion of the trial court?
Lordship may
Page number.
kindly comes to
Where
my
is that?
application.
Mr. Doctor, where is that conclusion of the trial court that we have raised this issue of Order 1 Rule 81, but the court had ignored it?
That,
In which part of the impugned order will I find that?
Lordship will find.
If you find it, you are right.
Lordship
But
will
where
find.
is it?
Lordship, page 119.
119.
This is our contention. The
Just
opposite party further contended that there has been no
Where
violation
are
of
you
order 1.
reading here?
After 6-7 lines, page 19.
Further contended that there has been no violation.
Yes. Of order 1, rule 8 of CPCS claimed and.
Who is
alleged by
the opposite
petitioner.
party? Plaintiff.
Yes. Plaintiff says
Ah.
that there is no violation.
Hmm.
That the alleged issue raised in regard of maintenance of the suit are not envisaged such and such for rejection of the claim. This is not the law. That is my humble.
No. They are making this thing no violation of Order 1. So according to you, as this is a representative suit,
Yes.
it has to be carried
Prior
forward only after prior
Prior
permission of the court.
But in the findings, Lordship will find that this contention of the party is not dealt with by the learned court in the findings at page 125. Not
Page-
touchable.
Page 1,
25,
24,
25,
25.
the finding.
So your first submission regarding Locust, we are not satisfied.
Lordship,
They have the Locust,
Lord.
but your second submission of non-compliance of 181,
Lord.
we'll look into it.
by border.
But first one,
Lord.
I'm still not convinced.
Lawyers have argued all points below. That is the
But
wisdom of the court.
Mr. Dutta, even I was a lawyer.
At the outset, I must say, Lordship
No,
has
Mr.
always, and
Mr.
Lordship has
Dutta,
goes to the root of the
Mr.
matter.
Dutta, even I was a lawyer.
Lord.
But I don't understand one thing. Why don't you argue the best point first?
Because the
Instead of
Lordship will
arguing-
catch up the last point. Lordship
no.
will catch up the last
No,
point.
no, instead of starting with the weaker or non-maintainable point,
Lord.
trying to urge upon it, why don't you start with the strongest one? That is, one ground is good enough,
Lord.
instead of urging 2 points.
I will try my best.
Because this is the issue to be gone into,
Lord.
definitely.
Please.
And 125, what you were trying to show? And are the allegations in the plaint against the individual defendants, or it is against the society as a whole?
No, Lordship, what happened? There is a dispute between the amongst the society. Lord. Now we published a notice, paper publication, saying that by the defendant 1 and 2, who are the president and secretary, that some impersonating the name of the society and its officials, some persons are acting against the interests of the society. Now they have challenged that notification by the SMC, that paper publication.
SMC had made a.
And is challenging the paper publication.
Who is challenged? SMC.
SMC.
It
Now
made
that-
a paper publication by whom?
By us.
Where is the paper publication?
That we have not annexed. But in the prayer itself.
Can I
Lordship-
take a look at the paper publication?
No, your Lordship will find. Yes, in the prayer, in the plaint itself, they have said.
So, society challenges a paper publication by the president and secretary of the society.
Yes,
That it is,
they cannot do it.
and what is the paper publication?
Paper publication, I mean, that is in the plaint itself.
No, what is the purport of the paper publication? Contents of the publication?
That we have, your Lordship, but it's in a Hindi.
No, it doesn't matter.
Okay, English.
Languages doesn't matter.
Yes, we have 2 papers we have published.
Just a minute.
Para 16 of the plaint.
Just a minute.
The entire paper publication was refuted. Page 30.
Come to page 37. There is an inconsistency between what you are submitting and what they are challenging, and what is provided in the prayer. And we are basically going by the prayer.
Yes.
Because prayer is the relief sought for on record. What is the first prayer? Declaration that plaintiff number 1 school managing committee represented by 2 and 3 are legally authorized person to manage the affairs of the school.
That is the English.
Just a minute. This has no connection with this notice.
Yes, nothing. Absolutely.
So
Absolutely.
why should I look into the notice?
No, it's the frivolous suit, your Lord.
How?
That that defendant number 1 and 2 means the president and secretary. Now,
No,
we say,
there is no defendant declaration.
No.
This
the second declaration.
second, that the defendant number one
One
have
and
no right and authority to interfere.
Running an operation of the school. I am the secretary and president. How could the SMC may interfere?
So
That's
this, Mr. Doctor, this is a issue to be decided by the court. What is the division of responsibility between the society and the school managing committee? If the school managing committee seeks to attain some more power than what has been actually vested to them by the arrangement, and also seeks to take away the power of the defendant 1 and 2, then the suit will be dismissed. But not that the suit is not maintainable.
Therefore, lottery will kindly.
So, how can an application for rejection of the plaint at that stage determine the true merit of the suit?
Not on the factual aspect at this stage.
But we are.
But no, I'm not factual.
But you may
My
not be.
saying is that unless the leave is granted by the court, this order 1 rule 8 lottery.
No.
The permission of the.
So this is what we are saying. This is not a suit against a society as such. This is a suit specifically against defendants number 1 and 2.
Who are the president and secretary of
Maybe.
we are the leader of the society.
Mr. Doctor,
Sorry.
suppose my courtmaster, in his own individual capacity, in the evening he creates some problem somewhere, and there is a complaint against that complaint. Can he take a stand that I am the courtmaster of court number 6, so this is not maintainable against me? These are two different.
I understand.
These are two different status. One, he is an individual in the evening to do some act somewhere. Two, right now he is discharging the duties of a courtmaster. If his acts pertain to his individual capacity in the evening, that is nowhere related to his. So similarly, defendant number 1 and 2, if in their individual capacity they have done something, that's an allegation, they cannot come out of it that we are also part of this society. This issue has to be decided. If the factual allegation that they had done something turns out to be untrue, suit will be dismissed. But that doesn't mean you will not allow the suit to go to that extent to be determined. So here is a case, we prima facie feel that order 1 rule 8(1) is not applicable.
But you kindly consider.
No, we will not consider. Why should we? Why should we consider something which is not on record?
Lottery will find that once the representative suit is filed.
This is not a representative suit.
This is the SMC is a temporary body.
Mr. Doctor, the requirement of being registered flows from the Societies Registration Act, and this SMC is not a society.
No.
So provision thereof are not applicable. They may file it on individual basis, they may file it on representative basis, they may file it in any capacity. So the objection normally we raise that you are an unregistered society is not applicable, number 1. Number 2, if I read their prayer, they may have written something in their pleadings. We don't know. We are yet to go into that. Reading the prayer, one relief they are seeking is declare our right to manage the school. Number 1. This right had already been bestowed to them by virtue of being appointed as the school managing committee by the society. 2, declare that 1 and 2 have no right to interfere. So this is a case where the plaintiffs will establish before the court that 1 and 2 in their individual capacity is interfering, and the 1 and 2 will defend that we are not interfering, and the court will decide. So where is the scope to throw out this litigation by taking recourse to?
I understand the query of the minister. Had it been the suit against the society, had it been
the
society,
811 would
Now-
have been,
now-
181 would have been
now
applicable.
actually what they are intending to do with this suit, that the dependent number 1 and 2 being
No,
secretary and
this is where you are at an advantage. Suppose in course of the suit, they rely upon any material pertaining to somebody other than dependent number 1 and 2.
So my difficulty
Just a
is,
minute.
I just explained this, Honorable Court, my difficulty. My difficulty is that they have implemented the dependent number 1 and 2 as an individual
Good enough.
capacity. Now,
Because their allegation is against 1 and 2.
now my paper publication or my activity is
No,
He
you're,
as president and secretary
Mr.
of the
Dotto,
society.
will simply clarify that this suit does not pertain to your paper publication. We are ready to clarify that. Because we do not find any correlation between the relief sought and the paper correlation. To that extent,
This is an application under. order-
Mr. Dotto,
No,
we
no,
are
no, I'm just a
we're ready to
alternative
take
there.
care of your
No,
problem.
alternative. I'm the lordship consideration alternative. This is Article 227 application. This issue, if you lordship decide or lordship.
We'll not decide. We
no.
are not sitting in a suit.
No, if the lordship deem it proper to consider my submission, that this type of suit has to be decided. Because suit will be, your lordship has a experience that is going on years to years. Now, at the first hearing and the order 10, this suit may be decided, your lordship. This suit may be decided.
Now you're on order 10. Okay, fine. Let us see what is order 10.
No. My limited prayer, the lordship will not at this stage divulge at that. Then they have said specifically, as lordship clarified, that we will clarify in the order
Mr.
regarding
Dotto,
the
Mr.
paper
Dotto, let us go back to what we have heard till now. First submission we heard from Mr. Dotto is that this school managing committee has no locus standi to file this suit. Therefore, the plaint is to be rejected. This is number one.
unregistered.
Don't mix up. Mix up we never
No,
allow.
second.
Never mix up. If it's a guava jam, let it remain guava jam. It's a mango jam, let it remain a
Right.
mango. Don't make it a mixed fruit jam.
Right.
Otherwise, we can never decide, nor you can ever
Yes.
argue.
Yes.
Go one by one. Your first argument is they have no locus standi to raise this suit against the society because it is the society who themselves have appointed this managing committee. Very well. Had this suit been against a third person, like the example we gave Mr. Decker, maybe it would have been maintainable. But what they are now urging upon is that under the arrangement being the school managing committee, we have certain rights to manage the school. Defendant 1 and 2 is disturbing us. So declare our right. Reading prayer 1 and 2 together.
Yes.
So this is a question to be decided on facts.
Yes.
Whether 1 and 2 is disturbing, whether the plaintiff does have the right to manage the school, this will be decided on the facts of the case, depend on evidence.
Yes.
There is no question of throwing out the suit at the initial stage that reject the plaint. Second point you are urging upon is that by taking recourse to Order 1, Rule 8.1, that if you have to file a suit against a society, prior permission of the court is required, which is not in the present case. To examine your second proposition, second contention, we examine the prayer made and also examine the defendants, who they are. Prayer is very simple. Prayer said, allow us to manage. Second prayer, declaration that defendant 1 and 2 should not interfere. So this is a specific relief claim against 1 and 2, not against a society. Although 1 and 2 may be a part of some society, but relief is not claimed against the society, it is against 1 and 2. Moment it is against 1 and 2, Order 1 Rule 8.1 is not applicable. Had one of the defendants been the society represented by President and Secretary, you are right. We are wholly with you.
In fact, we are the president and secretary. Your
That
lordship.
doesn't, I gave you the court master example. He has two status. One evening, he is his individual. He may do something. Two, he is the court master right now. His act as an individual cannot be related to a court master. Same is the case if a person may be a part of a society. If the act is related individually, alleged individually, it's immaterial whether he is a part of a society
May I
or not.
request your lordship to kindly see para 21 of the plain, where the paper
Page number?
is page 35.
35. But we have spent enough time. I think many others are waiting.
Yes, yes, Lord.
We'll continue tomorrow if you have to go
Yes.
to this length.
Your lordship, because
See.
It's a fight between the society and the SMC.
Doesn't matter. For us, we have to decide.
Yes, yes.
We have to
that's
decide
correct.
by facts, by law. That's all. Page 35, yes, 21. What is there?
That the act and conduct of the defendant 1 and 2 by publishing a public notice in the newspaper, namely Purvanchal Pravadi and such and such,
This is an incidental fact.
the furtherance of the illegal to take over the domain of the school.
Mr.
As per the-
Mr. Doctor, we'll clarify. We'll exclude the notice. In fact, if you want, we will delete para 21 of the
Lord. But lordship, one thing, lordship says I am to
See,
go down to this
Mr.
honorable
Doctor,
court.
you need not go down. You are here. We are here to hear you to your complete satisfaction. We never impose anything on
That's
the.
order 1 rule A, that is, your lordship will pass. That the interpretation, for my humble submission, is that once apparently is a representative by the SMC, apparently. Because all the members of the SMC are not party to this.
Understand, going by the prayer, it is not. Going by the prayer, the declaration or not to interfere will be only against 1 and 2.
Why
Just a
I'm saying
minute.
so?
Just a minute. If another member of the society interferes, this order will not be binding on them.
No, if the SMC, all the parties are not there, then the SMC
Sorry, I think we have given
SMC's member having a
Mr.
right to
Dotto,
say.
I think we have given you enough time.
No, lordship,
It's time to move ahead.
no, lordship, it's up to this.
But if you want to submit more, we can fix it up tomorrow. But these are the issues before the court.
Yes.
Because by this kind of a declaration, a third person belonging to a society will not be restricted from interfering.
May I request
From
your
the-
lordship
just a
to
minute.
issue a notice at this stage without saying the further proceeding? May I? Because this is an issue, your lordship.
Mr. Doctor, the issue by the High Court has a big impact on the trial courts.
Nothing, no. We'll
No,
not
it's-
stay, we are not asking for a stay of further proceeding.
Then why should you issue notice if there is nothing?
No, lordship, I'm leaving to the lordship.
Just think from this point of view.
No, no, I'm leaving.
And all your apprehensions will clarify.
That.
The
One apprehension.
the
I
prospective
have, your lordship.
difficulties you feel that you may face will clarify. Will
No,
not face.
I have an apprehension, this being I am a
Will clarify
president and
to
secretary.
will clarify to this extent that the relief sought for will be confined of restricting interference by defendant number 1 and 2, unrelated with any society, unrelated with any other member of the society.
Lord.
Clarify that.
Lord. And on the also the paper publication.
Paper publication is a material they are relied upon to show interference.
Yes.
They are not
That
challenging.
21 that
They are not challenging. In any litigation, you cannot restrain any of the parties from producing any material before the
No.
court. You cannot. I think you are a very experienced person in that. You also know the law.
Yes.
Material upon production may be rejected by the court, but production of material cannot be restricted. Every litigant has every right to produce any material they feel.
Take the
appropriate.
indulgence of this on podium.
But
Just
we'll also clarify that this is not a suit assailing this notice.
No.
This is a suit where the notice is thought to be used as a material against the defendants. We clarify it to that extent.
Yes. And also, Lordship is and consideration of the suit may be disposed within a short time because the SMC is only for 3 years. The 21 they have formed, 23.
To what extent we can do that?
That within a certain period, Lordship have under 2 to 7, Lordship may direct the trial court to dispose the suit within a period.
Suppose this judgment is reproduced in every suit. That in one case, High Court said do it within 3 months. So, so every litigant from tomorrow will rely on this judgment and trouble the trial courts that you have to do it within 3 months.
Facts and circumstances of this case. Not
Specific to this
necessarily,
one.
yes.
Okay, that we got it. We'll exclude assailing this notice by referring to para 21,
Yes.
and will only provide that it may be a material for the plaintiffs to rely upon
Yes.
to substantiate the relief sought
Their
for.
allegations.
2 relief sought for will be against defendants number 1 and 2 and not against the society,
Yeah, they have.
and
That-
also not against any other member of the society.
Any office bearer.
We'll clarify to that. I think your purpose is served.
No.
May not be directly, but indirectly, I think it's served.
Grateful to them. Always there.
Heard Mr. B. Dotol and Senior Counsel for the petitioners. The petitioners, namely Satyanarayan Agarwal and Prakash Kumar Vaid are arrayed as defendants number 1 and 2, respectively, in title suit 55/2022 in the court of the learned Munsif Tinsukia. Title suit 55/2022 has been instituted by the School Management Committee, Tinsukia English Academy, as plaintiff number 1, Raman Agarwal being the president of the School Management Committee as plaintiff number 2, and Ram Iqbal Yadav being the secretary of the School Managing Committee as plaintiff number 3. In the suit, the Tinsukia English Academy Society is arrayed as Society and Manav Kalyan Trust, respectively, are arrayed as pro forma defendants. At the outset, it is clarified by Mr. B. Dutta. No, in the suit, the petitioners herein made an application under, where is the rejection provision?
Order 7, Rule 11.
Order 7, made an application under Order 7, Rule 11 of the CPC for rejection of the plaint. Was the petition numbered?
Page
Order 7, Rule 11, petition numbered.
This case registered, your lord.
Which was registered as J case number 67, 2023. J case 67, 2023 was given a final consideration by the order dated 12/10/2023. And taking note of the provisions of Order 7, Rule 11, read with Section 151 of the CPC, the court was of the view that it was not a fit case for rejection of the plaint. And accordingly, J case 67, 2023 was rejected. Being aggrieved, this revision under 227, under Article 227 of the Constitution has been instituted. Mr. B. Dottal and Senior Counsel for the petitioners have raised two contentions for assailing the order impugned dated 21/12/2023 in J case 67, 2023. The first contention is that the plaintiff respondent school management committee Tinsukia English Academy had been constituted by the
society,
by the Tinsukia English Academy Society. And it being so, it has no locus standi to institute the title suit. Number 2, title suit 55, 2022. The second contention is that title suit 55, 2022 is essentially a suit against the Tinsukia English Academy Society. And it being so, there is a requirement to follow the provisions of Order 1, Rule 8, bracket 1 of the CPC, meaning thereby that it being a suit against a society, prior permission of the court would be required for institution of the school suit, which in the instant case had not been obtained. On the first contention that the School Management Committee Tinsukia English Academy has no locus standi to institute title suit 55, 2022, we accept the contention made by Mr. B. Dottal and its senior counsel that the School Management Committee had been constituted by the Tinsukia English Academy Society. But what is noticed is that the title suit 55, 2022 has been instituted seeking the following reliefs. Prior to Maridiva. page 37. The first relief sought for is for a declaration that the School Management Committee of Tinsukia English Academy are legally authorized, being represented by plaintiffs number 2 and 3, namely Raman Agarwal and Ram Iqbal Yadav, are legally authorized persons to manage the affairs of the school. Is for they are legally authorized. And the second declaration is that the defendants number 1 and 2 in the suit, namely Satyanarayan Agarwal and Prakash Kumar Baid, have no right and authority to interfere into the running and operation of the management of the school, that is Tinsukia English Academy. If the contention of Mr. B. Dottola and the council is to be accepted, that the plaintiff School Management Committee Tinsukia English Academy had been constituted by the Tinsukia English Academy Society, we have to understand that by virtue of such appointment, certain rights had been bestowed upon the School Management Committee Tinsukia English Academy for carrying forward the management affairs of the Tinsukia English Academy. If any authority is interfering with the exercise of the legal right of the plaintiff School Management Committee Tinsukia in discharging the management affairs of the school, we see no reason is noticeable as to why the School Management Committee Tinsukia English Academy cannot institute a suit for a declaration of their legal right to manage the affairs of the Tinsukia English Academy. It is of course another matter as to whether any person or entity is interfering with the right to discharge to manage the affairs of the school. But it is another aspect that the School Management Committee does not have the locus standi to institute a suit alleging interference with their right to manage the affairs of the school. From such point of view, we have to reject the first contention on behalf of the petitioners in the present revision that the respondent School Management Committee Tinsukia English Academy does not have the locus standi to institute the suit so as to warrant a rejection of the plaint. In this respect, we take note of the provisions of Order 7 Rule 11 of the CPC, which is extracted as below. Change kuribani di golobo. Mati lahir mati dia. Boleh kita kan? Mati dia. A reading of the provisions of Order 7 Rule 11 makes it discernible that a plaint may be rejected where it does not disclose a cause of action or where the relief claimed is undervalued and the plaintiff, upon being required to correct the valuation, fails to do so, or where the relief claim is properly valued but the plaint is written upon paper insufficiently stamped and the plaintiff fails to incorporate the necessary correction, or where the suit appears from the statement in the plaint to be barred by any law, or where it is not filed in duplicate, comma, or where the plaintiff fails to comply with the provisions of Rule 9. Or where the proviso thereof is applicable regarding that time provided for correcting, for incorporating the necessary corrections. In the instant case, the contention is, first contention raised is that the plaintiff school management committee, Tinsukia English Academy, does not have the jurisdiction to institute a suit, which again, on a conjoint reading of the relief sought for, does not prima facie makes it acceptable that the school managing committee does not have the locus standi. On the other hand, on an allegation of some interference in their legal right to manage the affairs of the school, it appears that it is not a case where the plaintiff does not disclose a cause of action. Yes, sir. On the second contention raised by Mr. B. Dotol and Senior Counsel, that this is a suit essentially against the Tinsukia English Academy Society, and therefore the provisions of Order 1, Rule 8.1 would be applicable. For an effective adjudication, we refer to the provisions of Order 1, Rule 8.1, which is extracted as below. A reading of the provisions of Order 1, Rule 8(1) makes it discernible where there are numerous persons having the same interest in one suit, comma, one or more such person may, with the permission of the courts, sue or be sued, or may defend such suit on behalf of or for the benefit of all the persons so interested. Reliance is placed upon Order 1, Rule 8.1 to substantiate the contention that the title suit 55/2022 is essentially a suit against the Tinsukia English Academy Society, and therefore there are numerous persons who are having the same interest in one suit. In order to appreciate the contention of Mr. B. Dotto, we again refer to the relief sought for in the plaint in Title Suit 55/2022. It is noticed that the second relief sought for is that the defendants number 1 and 2, namely Satyanarayan Agarwal and Prakash Kumar Vaid, respectively being the president and secretary of the Tinsukia English Academy Society, be restrained from interfering with the management of the school by the plaintiff Tinsukia English Academy Managing Committee. A plain reading of the relief sought for makes it discernible that Title Suit 55/2022 is essentially for restraining the defendants number 1 and 2, namely Satyanarayan Agarwala and Prakash Kumar Vaid. And no relief is being sought for against the Tinsukia English Academy Society as a whole, or against any other member or person associated with the Tinsukia English Academy Society. To substantiate his contention that Title Suit 55/2022 is essentially against the Tinsukia English Academy Society, Mr. B. Dotto, Learned Senior Counsel, relies upon a public notice dated 21/9/2022 issued by Satyanarayan Agarwal, President Tinsukia English Academy, and Prakash Bhatt, Secretary Tinsukia English Academy, that the Title Suit 55/2022 is essentially against a said public notice. It is the further contention that the referred public notice is by the defendants number 1 and 2 on their as per their status as the president and secretary, respectively, of the Tinsukia English Academy. To further substantiate the said contention, reference is made to the amendments made in paragraph 21 of the plaint in Title Suit 55/2022, wherein it is provided as extracted. Page 35 what I say. A conjoined reading of para 21 of the plaint with the relief sought for does not make it discernible that the public notice dated 21/9/2022 is being assailed in Title Suit 55/2022, which notice essentially had been issued by the defendants number 1 and 2 on their capacity as the president and secretary, respectively, of the Tinsukia English Academy. A reading of para 21 makes it discernible that the said public notice is sought to be used as a material by the plaintiff, Tinsukia English Academy Management Committee, to substantiate their allegation that the defendants number 1 and 2 are interfering in the management, interfering them in managing the affairs of the school. A material sought to be relied upon in a proceeding may either be accepted or rejected by the court in course of its adjudication. But reliance upon a particular material cannot ipso facto lead the court to accept that the material relied upon itself is being assailed in the proceeding. We are not expressing any view on the merit of the allegations raised in Title Suit 55/2023 that the plaintiff Tinsukia English Academy Management Committee has the legal right to manage the affairs of the Tinsukia English Academy, and that there is interference in such legal right by the defendants number 1 and 2, namely Satyanarayan Agarwala and Prakash Kumar Bhatt. But what is noticed is that the plaintiff seeks for a specific relief of being restrained from interfering with the managing the affairs of the school in by the defendants number 1 and 2 respectively, Satyanarayana Agarwala and Prakash Kumar Bai. And it does not seek for any relief against the Tinsukia English Academy Society as a whole or against any other person associated with the society. From such point of view, it cannot be construed that Title Suit 55/2022 is against numerous persons having the same interest in one suit. On the other hand, as already arrived at, the suit appears to be specifically for restraining the defendants number 1 and 2, namely so and so, from interfering with the legal right of the plaintiff, it is school managing committee, from managing the affairs of the school. In view of the above, we do not notice any applicability of the provisions of Order 1, Rule 8(1) of the CPC, requiring the plaintiffs to obtain prior permission from the court to proceed against the numerous persons, as has been alleged in this petition by the defendants number 1 and 2. From such point of view, we do not notice any infirmity in the order impugned dated so and so in Miss Case number so and so. Order impugned 12/10/20 in Miss Case J 67/2023. But however, we are clarifying that this adjudication is made on the premises that the relief sought for in Title Suit 55/2022 is for a declaration restraining the defendants number 1 and 2, namely Agarwala and Bai, from interfering with the affairs of the, from interfering with the legal right of Tinsukia English Academy School Management Committee from managing the affairs of the school.
In their individual capacity.
Just, it's good enough against them and not against any other person or the Tinsukia English Academy Society as a whole. This is good enough. Secondly, we are also clarifying that Title Suit 55/2022 should not be construed to be a title suit assailing the public notice dated 21/9/2022, issued under the signature of Satyanarayana Agarwala and Prakash Kumar Bai, respectively, being the President and Secretary of Tinsukia English Academy Society. Although the said public notice may be relied upon by the plaintiff managing committee to substantiate the allegation made in title suit so and so, subject to its admissibility and acceptability under the law.
Please kindly that should be disposed of because
it is we've also find substance in the argument of Mr. in the submission of Mr. B. Dotol and its senior counsel that it being a suit by a school management committee who is constituted for a period of 3 years, that the suit itself be decided at the earliest so that the issue involved can be given its finality. Accordingly, the learned Munsif number 2, Tinsukia, is requested to complete the proceeding within a period of 6 months. 6 months from the date of receipt of the certified copy of the order. And we also require both the plaintiffs, namely the Tinsukia English Academy School
Management
School Management Committee of Tinsukia English Academy, along with its president and secretary being the plaintiffs number 1 and 2 and 3, as well as the defendant number 1, E. Agarwala and Kubasman, as well as the Tinsukia English Academy Society, to cooperate to the fullest extent so that the matter can be disposed of within the period as indicated above. Matter can be in the final consideration within the period.
Great.
Okay, thank you.
Great.
Item 17 and 18 for admission.
And 18.
Item 19.
You are there in 17 and 18.
17, 18 and 19.
Huh. What is to be done? Some partnered matter.
Yes, on the last petition, Lordship, the report was sought from the.
XT.
Lordship, we have referred the matter to the CID for investigation of the matter.
There's an earlier order.
Lordship,
Was there an earlier order to refer it?
Lordship had called for constitution of the SLST committee to examine the cases of the petition.
Sorry.
Lordship had in last order.
See, Mr. Das, right now it's order 1, rule 81. Order 10, rule 11 for the time being. Please be a little slow, but just indicate the background.
Last court order, your Lordship has passed an order.
No, Mr. Bora's client is somebody who is holding a tea garden laborer certificate. He seeks admission in the school represented by Madam Chaudhary. School is having some doubt about the certificate on the acceptability. So Mr. Bora's client is before the court. We have referred it to the special committee. And why CID?
Because there was an order of the division bench. The earlier order which your Lordship had passed, all the orders which was. That is why this time Lordship, they have directed the director of director of.
What is the order of the division bench? Definitely not in this case.
Not even.
That is something different.
Lordship.
And to our knowledge, the core determination of entry 24 had not been interfered. The requirements had also not been interfered. What has been provided is that the time given was little short. Although there is a reason why it was short, that was not pointed out to the division bench, nor the division bench had gone into it. The shorter time was given because of the cutoff date of 30 September, so that if a fraudulent person is there, the genuine person gets an opportunity to get admitted. But that was ignored by everyone in the division bench. I don't know why. That was the reason, not because of anything else. Otherwise, we are also aware that 3 months' time is the required. That was a special case, but the special situation was not reflected. We have to be very forthright with it. And now what is the difficulty?
Lordship, although your Lordship had directed the petitioners to appear before the state level scrutiny committee, they have failed to appear. No petitioner has appeared before the state level.
If they have not appeared, it is to their detriment.
By complying the honorable court order, they have referred the matter to the CID.
Who? CID, what they will do? I know, but what will CID do here?
CID will investigate the.
CID has no authority to investigate. It is only the special committee.
Special committee is being constituted.
No. Why are you not appearing? To get yourself clarified?
That observation is in respect of item number 17. That is why these 2 items have been kept as part of it. We are not directed to appear before the committee. As if your Lordship reduces the last order.
Item number?
Item number
Read petition number?
3975.
3975, petitioners to appear before in the chamber of the society
And the second paragraph, if lordship. we
shall
kindly see.
determine as to which forefather of the petitioner
Petitioner
what
number-
is.
So here there are 9 parents. It is in respect of Sonu Singh, petitioner number, repetition. Number
How many petitioners are there?
1 and 2, the reflected in the order dated.
No, we'll correctly modify the order
Yes,
if
yes.
necessary, but
There
you
is-
go and appear.
Yes, lordship, there is
You
no.
go and appear, get yourself cleared.
Yes, in fact, our.
If
task
you
is-
actually belong to the constitutional class
Yes.
recognized by the constitution,
Yeah.
take the benefit.
Yeah.
But if you do not belong,
Yeah.
either the certificate was wrongly issued or it was fraudulently obtained, we are not expressing any view, then you are not entitled. Otherwise, this will be a constitutional fraud.
Yeah.
And no court of law, whether division or single, can ever ignore a constitutional fraud being committed. Nor any question of natural justice can come in the way. If natural justice in the way, get your natural justice done. For that, go and appear before the committee. Mhm. I don't know. Go and appear. If you don't, it is for your detriment.
No observations inside.
If you don't, it is to your detriment.
There is no
See,
difficulty on our part.
or no, now possibly there is an interim order in your favor.
Yes.
They are all 29.
Okay, no, if you don't go, we'll withdraw we'll recall the interim order. Keep the matter pending. Definitely. Firstly, financial burden on the school. Secondly, you are depriving one genuine student who is entitled under the constitution. That is more of a concern for the court. There are two aspects in these matters. Unfortunately, only one aspect was highlighted: natural justice of the persons who are likely to be terminated. Okay. What about the legal right of the genuine people who are being deprived? Are they to be thrown to the dustbin? Constitution and the law of the country had created certain right for a particular class of people. Another set of people are wrongly claiming to be belonging to that class of people, meaning thereby the genuine class is deprived. Don't you think, Madam Chaudhary? And they are trying to do justice to the whole issue.
When they apply,
And natural justice will not give you any legal right to commit a constitutional fraud. Mind you, we are very clear in our thoughts. Whatever, whoever may say whatever you want. We are very clear. If it is natural justice, we can give you an opportunity to prove a case. But that will not render you to be entitled to a constitutional right which a constitution has not given, and that too by committing a fraud. Let our views be clear. So go and appear.
Yes. Will appear, but before.
If Mr. Das says we need some more time, we can give you more time, but that is another aspect.
But department is also referring us before the CID.
No, we are not referring, since they have not appeared before the committee.
What else they can do? They are under two kinds of pressure. One, they are required to make a determination. Two, there is a pressure from the genuine student from the school side that they are required to give it. But you are not going. Why? You are enjoying an interim order of the court.
No.
Then let us recall the interim order. Let us recall the interim order. School will appoint the genuine people.
Will appear. Go and appear.
This is the second kind of fraud you are committing. First fraud is a constitutional fraud of wrongly obtaining status which you are not entitled. Second, by having the benefit of an interim order getting admitted, let us delay the matter so that this session is completed. Tomorrow I'll take a stand that I'm already in, let me remain. That too in spite of the direction of the court to appear. This is the second fraud you are committing. So why should we encourage fraud after fraud?
If I may submit, Dr. I misunderstood the order because the last part of the order says the petitioner number 1 and 2 should go and verify. That is why, here we are 9 petitioners.
In WPC 3975, 9
Yes, yes.
petitioners.
Yes. The committee shall determine as which forefather of the petitioner number 1 had worked as a tea garden laborer, in which tea garden and for what period, and thereafter submitted.
So if you have passed this order, definitely you did not
That is-
urge upon on behalf of the others.
No, that is in respect of actually item number 18.
18, okay.
Yes, 18. That is why I misunderstood.
3975 is item number 17.
Hmm.
His item number is 3976.
No, no.
Where?
3975.
I am holding 3975 Konaklota Chauhan.
Yes.
Ah,
The
yes,
first paragraph says that petitioner should go. and
this
appear
had
in the
happened because it is a submission from the council that the same order will do everywhere.
Yes,
Yes.
because of the common.
But if the same order will do and petitioner number 1 and 2 is in reference to another writ petition, and if in your writ petition there are more number of petitioners, this order has to be read to be petitioner 1, 2, 3, 4, 5, 6, 7, 8, 9, up to 9. This is the third fraud you are trying to commit,
No, Dr. Bai,
trying to give a wrong interpretation to the
I
court order.
misunderstood.
Don't misunderstand. Don't misunderstand. Go and get it done.
In fact, on that.
So did you feel that in the other writ petition, they'll have to go and appear and get themselves cleared by the committee? But for your petitioner, that is no
Yes,
requirement. There is a presumption that you are a genuine candidate.
Because
Did you ever think in that
No,
line?
Your lordship,
Then-
your lordship observed that, already observed that, item number, in my item, your lordship, on last.
See,
occasion said
Mr. Then from now onwards, if you take this kind of stand, we are going to do away with matters being listed together.
that, No, on.
We'll
last
hear every petition individually, we'll pass individual
occasion,
orders.
kindly hear me for a moment.
From tomorrow, moment anybody makes a submission, let it be listed together, straight rejection.
Lordship, on
If
last,
you want to take this kind of advantage.
I'm saying something, different. On last occasion, lordship, I placed a.
Nothing, Mr. Bora, you understood everything.
No, I'm not
You
saying
just
that.
thought it out that this will be a good possible excuse, let me
No,
play
no,
with
no.
it.
I'm saying something different.
There's nothing you were saying.
On last occasion, lordship, I placed a notification as well as an act of Assam Backward Classes Commission Act. The moment I placed that act, your lordship said that in item number 56 and 57, your lordship will hear me on 6.
So today you want to be heard again.
No, no,
Start, argue,
I'm not saying that.
argue.
But your lordship,
No, you are saying, please argue, Mr. Bora.
since it was. Your
Yes,
lordship said
since we are accepting your submission, you argue.
And why
You
my
argue,
learned
please.
friend has said that they are referring it to the CID.
Please argue.
Yes, and
Let him say whatever he wants to say. You argue your own case.
this committee lordship, this state level caste screening committee, they can't convene on their own. The director, as per Madhuri Patel's judgment, paragraph 13, subparagraph 8, it says
From
that
Madhuri PSA.
1994, 6 SCC 241, paragraph 4, 5, 6, and 7 of paragraph 13 of
Let us take a look.
1994, 6 SCC 241.
Mr. Bora, kind of way direction you are going, I think they are right in referring it to the CID.
Yes, yes, they can do it, lordship.
Hmm. You are only trying to avoid,
13.
nothing else.
13, paragraph 13. Paragraph 13.
Let us see what he provides. And nor technical objections can override a constitutional fraud.
In
Keep
fact,
that in mind.
I'm ready to go and I will appear.
Then go and get it done.
Yes, I'm ready. I will appear for the
Go.
committee.
You can go.
But what Madhuri Patel says, I'm just pointing it out.
What it says, that you should not go.
No, no, not.
Then
Paragraph 4, 13, 13 of subparagraph 4, it says all the state governments shall constitute a committee of 3 officers, namely an additional or joint secretary or any officer higher in rank of the director of the department concerned, director social welfare, tribal welfare, backward classes welfare, as the case may be. That means 2 officers have to be there.
so you are challenging the constitution of the committee now. Are you trying to suggest that?
No, 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 I'm not. saying it.
Then what are you suggesting?
And paragraph 5, each directorate should constitute a vigilance cell consisting of senior deputy superintendent of police in overall charge and such number of police inspectors to investigate into the social status claim. The inspector would go to the local place of residence and original place from which the candidate.
So that's why they are referring to the CID.
Yes.
They have done the right thing.
The
Yes,
committee
now?
committee, they can sit only when there is a report from the directorate of the vigilance cell. That is one.
Otherwise not.
Yes, that is what.
So you mean to say High Court under 226 has no jurisdiction?
Not if that committee.
And that too in your own petition.
Not if that committee is formed.
So do you mean to say that because of this paragraph in Madhuri Patil, now I should allow your petition.
No, no, I'm not
Let the
saying.
constitutional fraud be committed because the director is not constituting a committee.
In fact, what I'm trying to submit is that let the director go, let the exercise be done as per the judgment of the Supreme Court.
Why?
Court
What
says
legal
that-
right you have? What legal right you have?
Okay.
What legal right you have? All that the requirement is there must be a committee and the committee should inquire.
Yeah.
These are not mandatory requirements. These are directory provisions. And no legal right can be bestowed to you because of that. Go and appear.
I'll do it.
File an affidavit. We are listing tomorrow when you are going to appear. Let us stop this mischief. You choose your date and time. We'll request Mr. Das to accommodate you.
Yes.
You file when you are going to appear. I know. Everybody, see, Madam Chaudhary, we are aware, everybody is trying to play this game. That let us delay, we'll continue.
In fact,
Nothing else.
In fact, on last.
In a medical admission, same thing. Here also same thing.
They were moved for the vacation meant of the July summer vacation without serving a copy on us. And the interim orders were
And
obtained.
then we do one thing. For tomorrow, we fix it up for hearing or continuation of the interim order.
In fact, on last occasion, when I placed that Assam Backward Classes Commission Act, your lordship posed the question to me that whether state government has the power to include or exclude in the reserve category or as a OBC. So that question
Does not have. Our question will not give you a legal right to continue with the proceeding. Please, Mr. Bora, come to terms. Come to terms. Get the core issue decided whether you belong to Tea Garden Labor Committee or you do not belong. That's all. Rest are all formalities. That's a core issue. Formalities cannot have precedence, and having precedence, we allow you continue with a fraud. Definitely. Or else we fix up tomorrow for hearing on continuation of interim order.
document can fix it day after tomorrow.
Why?
I'll have to go through it properly.
What will you go through it?
There are certain broader issues
Which broader issue? Please argue.
which I believe.
How can I give you time for a future preparation of a case if you are not prepared today? Nothing doing. No litigation can be brought to an end with this kind of submission. That I want to prepare something more, and I don't know what I'm going to prepare.
Lordship,
What you are going to argue? Tell us.
on last occasion, your lordship, in fact, my learned friend on the other side said the state government does not have power to include or exclude a particular community in the other backward class.
They are right.
No, 105th amendment of the constitution, which is enacted.
So how does it matter to you? Did the state government include them?
We had placed some kind of a notification on the last day saying that the Nulia community has now been brought in under serial number 34 of the list. Now, I also tried to check up the website. On the website, that notification was not.
Where is
there.
that notification? Let us see. Why don't you ask your client to read better, come on merit and get admitted instead of trying all these backdoor methods? Was this, who appears for the government? Principal Secretary, Social Justice Empowerment Department? You appear. Was this notification issued?
Not, it is not available on the.
I know,
tried taking
Mr. Das can give the info. Was it issued?
I'm not.
Hmm.
In any case, not if in any case, even if it has been issued, this has been issued subsequent to the institution of the writ petition. When the writ petition was instituted.
That certificate is not valid.
that
He may
certificate is not
obtain a
valid.
new
It's-
certificate.
In future,
In fact, in
future,
future, we can settle this issue. That is
Yes.
why I'm referring it. Lordship.
so
In future, we come in future when you
if-
don't get.
If the child applies
Respect
next
of
year,
these
perhaps
petitioners,
this might help.
Oh,
the child.
nothing doing for this petition.
Where is the question of relying on this particular
See,
notification insofar as this writ petition is concerned.
slowly we are getting more and more concerned for those genuine tea garden people who are deprived all along. We are more concerned with them. Medical seats are already gone because of all these technicalities raised. Ultimately, 3 months is given. If you succeed, it is good. If you are a genuine tea garden, if you are not, you have spoiled one seat. You have deprived one genuine person from getting admitted. Because that man now, after September 30, cannot do anything.
Financial burden will never be able to be
Yes.
compensated, your lordship. They will never compensate us for the
Nothing.
financial burden.
The whole
And
confusion
when we are trying to expedite, you are raising issues of natural justice somewhere. Time is very short.
the whole confusion is because of, there are two lists.
What tool list?
One is saying, if your lordship kindly peruse.
Which tool list you are referring, Mr. Bora?
Lordship, Your lordship's peruse page 101 of the affidavit opposition filed by the Noida Vidal.
We don't know 101.
This
running
notification
page
of
number.
1993.
Running page number. Running page number and writ petition number.
3975.
3975. Running page number. Madhuri Patil to আছে ইয়াত
কি চাব বিচাৰিছে?
এই মাত্ৰ দিলা নেকি
99.
page number 99. What is this?
Here, lordship, where actually I'm just stating the fact that your lordship is.
This is some gadget of India. Yes.
Yes.
What do you want to refer?
The state Assam common list.
Ah,
Serial number is there. Name of cases, common communities, including Sapka synonyms in the
Sorry?
common list of
sorry.
name of castes are there. And
Name
then
of?
Name of caste that is are there
Huh.
along with the serial number. On the right side, your lordship may kindly say entry number in state.
Huh. So,
This is where the problem is.
what problem?
Now there are some certificates which are issued on the basis of the state list.
Which state list?
Entry number in state list, entry number in mandal list, and then remarks column is there.
Huh.
Now, which list has to be treated as central list?
Sorry.
Which list is required to be treated
You
as
go and ask
central list?
them. We have no, court has no business to answer to the litigant.
That is
We have
why,
only,
lordship, all this
nothing is
confusion
there.
arises.
Sorry. Now, how does it, just raising issue after issue is not a matter of presenting before the court. Just to create a confusion and block everything.
No, since your lordship.
So how does it matter? Suppose which community your petitioner belongs to?
Serial number 75, lordship.
75. What is it?
100. Nunia.
Sorry?
Nunia.
75 is not a individual entry.
It is under sub, it is
It
a
is
sub-entry.
under sub-entry of
Yeah.
24.
24.
Yeah.
So how does it matter to you where Nunia is?
Now, again, this notification comes in which says that I am at serial number 34.
Which notification?
The notification I placed.
If you say that 34, you get under 34 from Mr. Bora. If you were 34,
Yes.
establish your legal right after 23rd August 2023.
Correct, sir.
It has no retrospective operation.
Don't even think about this. for the time.
This one has no retrospective operation. And serial number 34.
Yes, 34 is nowhere in the thing.
34 is not there.
Yes, that is what on last occasion I in fact submitted that.
So
I
how can
I
you
was-
take advantage of their mistake? If it is not there, it is not there.
I think there is a list which includes. serial
Produce
number
it.
34. No, that list is
Let
not
him
with me.
produce
The
that
only the
list.
government.
You get it.
Let him
It
produce
is your
that
argument. You
list.
get the list.
There's no mention of that in the writ
Oh,
petition.
sorry. Mr. Das, what is this? Ask your principal secretary. We want to take it up today itself. Ask him over phone, send him a scan copy or photocopy of this one.
No.
Ask him what is this and what does he mean by this. And even if it is,
Yes.
this is your legal right after 23rd
Yes, yes,
August.
I understood that.
And this has no bearing in this present
Yes, yes.
litigation.
In fact, this will not help me in my case, but this will
Then why
obviously
are you
help in settling the issues if any issue
No,
will arise in.
Sorry, again, your third confusion you are trying to raise, as if this is having retrospective operation.
But if tomorrow some other candidate will suffer, that is why this.
Let them-
This
you-
PI, it's not public.
You are not a
interest litigation.
PI.
You should
You're
be
right.
concerned about some other
You
candidate.
establish your own legal right.
That I understand.
If the community you belong to is enlisted as a OBC on the date when the certificate was issued, you take the admission. If you are not, give way to the genuine candidate.
Yeah.
Don't commit a fraud. And if you are included from 23rd August 2023, claim your legal right after that date. Not for the cause of action which had arisen prior to that date. Let us draw the lines. It's one way, good way of arguing matters, create confusion, broaden the scope, and let the court not decide it. Will not allow you to do that. Tomorrow? Can't I just provide you this tomorrow? Tomorrow for what purpose? Tomorrow for to enable the petitioner to file an affidavit as to on which date they will appear before the state level cost scrutiny committee.
In that case, the lordship may fix it tomorrow, day after tomorrow, and I'll file the affidavit by tomorrow. That will come on record.
Bring your record is the court master's headache, not your headache. You file it, he'll ensure that it is there.
Like tomorrow.
Tomorrow.
Okay.
So 19 or like order.
In item 18, my lord, we have already appeared.
You go by the decision. And whatever you have to say, we are not stopping you from
17,
proving your
18,
case in any manner. You prove your case before the committee, that you belong to the committee. And the court adjudication is not interfered by anyone.
Lordship.
The core adjudication, that first consideration is TGL. Second consideration, whether you belong to the 96 communities, is not interfered by any court till now. It remains, I believe. Only thing, what was slightly interfered was granting some more time to establish.
Madhuri Patil, the time limit was 3 months. Since your lordship had given us slightly lesser time, therefore perhaps.
Lesser
taking all
time,
the
of course,
considerations, the court had helped.
we expressed our reason why it was
Correct,
given,
correct.
to take care of the genuine candidates.
Correct.
If you don't want to care of the genuine candidates, you extend the time.
Even though this is an admission matter of students, we are not concerned.
But
as to who
school
is-
matter 30
who
September
gets-
is not applicable.
Correct. But
That was medical admission.
therefore, we can perhaps undertake that exercise. And in fact, my learned friends' clients are the ones who are the most, they only have there are only 2 children in the petition filed by Mr. Ali. And here there are almost 27 students. If they're deliberately delaying this matter, saying that we misinterpreted the order, or just.
No,
Since-
tomorrow we are recalling the interim order. He will be out, genuine will be in. And the genuine admission will be
Some of
conditional
them-
subject to the result of the petition.
My contention is not that most of his, some of them might be genuine,
Might be.
might be. but
Maybe,
then At
maybe,
least they should go and appear.
maybe
Why-
all 20, maybe, Madam Chaudhary, maybe all 27 are also genuine. No only saying you are not genuine. Go and get yourself established. That's what we require.
Item 20.
You used to a RERA appeal. Tare order against a writ petition. But appeal. It's a statutory appeal.
Well, lordship, I'll see the last order, right? It has been, it's hard on substantial questions of law, man. That has not been.
No, let us, today the other court will take up or I'll take up?
No, no.
We'll take up. Let's just begin from the,
Well.
start from the beginning. Where is the appellate provision?
Section 58.
58. Section 58. Any person agreed by any decision or whatever, yeah. Within the period of 60 days. It is within 60 days?
My lord.
No difficulty. Or whatever. Grounds specified in section 100 of the CPC. So this real estate project is in Assam.
Yeah, Assam.
No appeal lie against decision or order made by the appellate tribunal with the consent of the parties. Very well. So now all that we have to see is on a ground as appearing in section 100 of the CPC. Oh, second appeal. Substantial question of law. Memorandum appeal shall precisely state the substantial question of law. Which page?
Substantial question of law.
Let us first see.
Substantial question of frame.
Where is the substantial question law in the memorandum of appeal?
We have not framed separate.
We have to. Because section 58.
58. Read it, section 100 of
Section 58. Section 58 is very clear. Within the period is on any one or more of the grounds specified in section 100. So ground specified in section 100 is it must be on a substantial question of law. And subsection 3 says it must be specified in the memorandum of appeal. Have you done that? Then you do it. Otherwise, how can you proceed further?
I have to do it. That is discussion in the court matter.
Sorry?
After this discussion in the earlier court matter.
Don't discuss it with anything with the court. You follow the law that is required.
I will not search an order of the Allahabad High Court. I searched the Allahabad High Court order. Allahabad High Court stated my lord, appeal is not a second appeal, regular second appeal.
Is not a regular second appeal.
Summary appeal, my lord. Therefore, that appeal, my lord, regarding the deposition of the court fee as a second appeal. That case was listed as a defective matter, my lord.
No, we are not asking you to deposit court fee. We are asking you to state in the memo of appeal the substantial question of law. Is it there? Then Allahabad is of no use.
I have to satisfy that point. Because Allahabad said that it is a summary trial, therefore it cannot be treated as a regular second appeal.
We are not treating. We are treating it as an appeal under section 56 of the RERA Act. Section 56 says it will be on any of the grounds provided in section 100 of the CPC. We are never saying it is a second appeal. Section 100 requires there must be one substantial question of law. It also requires that should be stated in the memorandum of appeal. Allahabad never said that you forgo everything. Then you provide that law. Mr. P. Saikia, learned counsel for the appellant, seeks for an adjournment to provide in the memorandum of appeal the substantial question of law that may have been raised in this appeal with reference to section 56 read with section 100, section 50 of RERA Act read with section 100 of the CPC. When do you want? 58. When do you want? List on so is paid for. Once you bring in this substantial question law, we'll examine whether it is right or wrong.
Item 22.
The regular first appeal, my lord. My plaintiff was dismissed for the first time.
Sorry, Mr. Munta.
With the regular first appeal, I raised the dismissal of my statement. First time.
Item given
22.
21 to है क्या नहीं? Adjourn.
Statutory appeal.
No, admit it.
My lord. Admit
Any interim order?
No, there is no interim.
Heard Mr. T.J. Mohanto, learns in a counsel for the appellant. Admit.
Call for the record.
Returnable 4 weeks.
My lord.
Call for the records of title suit number 208/2015 from which court?
From
the
civil judge.
Court of the Civil Judge, Senior Division number
2, Kamrup.
2, Kamrup Metro. Steps by registered post.
Thank you.
Thank you.
Item 28 for orders.
This case, Lordship, I pray, Lordship, 2 weeks time to take fresh steps upon respond number 3, Lordship.
28.
Yes, sir.
You want to take steps.
Yes, upon respond number 3.
Petition allowed to take first steps on respondent 3 by registered post 3 days.
No,
One-
Lordship, 2 weeks because correct address I have to collect, Lordship, from Lakhimpur.
Acha, it's steps within 2 weeks.
2 weeks.
Steps, কি করলো? Allowed to
Step.
take steps. 2 weeks time granted for taking your steps in view of the requirement of the petitioner to find out the correct address of the
Obliged.
petitioner.
29.
Next. $29 R Hazarika. What arbitration? With 29, right?
Item 29.
You're there?
Yes.
Want for appointment of an arbitrator.
But actually,
Earlier,
yes,
Mr. PC Borpuzari was appointed.
yes, sir.
What happened?
Uh,
Then
Lordship,
this should have been closure of the petition.
No, Lordship, we have filed an IA for change of arbitrator.
Change, why?
But actually, the PC property has got some personal difficulties. Lordship, I think it's in a record as letter L.
Hmm.
He has given a
Achha, Mr. Borpuzari has refused to
Yes.
letter L. Where is letter L?
letter dated 13/2.
अरे L क्या पाई? हाँ. Okay. So
So now, Lordship, we want we have to file an application for appointment of
on the prayer this matter next week heard Mr. You are R Hazarika.
No, Lordship, I'm BP Sharma.
Sorry. So you want to go for arbitration?
Fine.
I'm not your senior. You don't mean you as a lawyer.
Yeah,
Your
yeah.
client wants to go for
Yes,
arbitration.
yes.
Respondents, they are not responding.
Actually, not aware of.
Hmm. Do you have any particular name in your mind whom you want as an
Yes, Lordship,
arbitrator?
I have given in the IA Mr. Biswajit Talukdar, senior
Mr. Biswajit
Biswajit Talukdar.
Talukdar.
Yes.
You want him as an arbitrator?
Yes. We block five.
Will Mr. Talukdar agree?
Yes, we have, I think,
We'll take it up day after tomorrow. You confer with Mr. Talukdar.
Yes.
If he agrees, we'll appoint him. No
Yes.
difficulty. Okay.
obliged.
Because again, if Mr. Talukdar is not accepting, same thing will be repeated again. So better take the confirmation from Mr. Talukdar.
Yes.
Your name, P. Sharma.
BP Sharma.
Mr. BP Sharma, then counsel for the petitioner. What is that document you are holding in your hand?
I
By referring to paragraph
paragraph 5.
5 of IA 137/2020.
Yes. No,
There is no other IA before us. Wait, IA 2791/2023.
yes, filed on the
Suggests the name of Sri B.J. Talukdar, Learned Senior Counsel, to be appointed as an arbitrator. Mr. Sharma seeks for an adjournment to confer with Mr. Talukdar whether he is agreeable to accept the assignment.
obliged.
Listed.
Item
Yes, sir, tomorrow
30.
Friday. Day after tomorrow?
Thursday.
Thursday.
9, not ready. Item 30.
CRPIO. Yes, none appears for the petitioner.
The respondent,
Hmm.
your lordship, I am for the respondent. Defendant.
It appears from the order sheet that on 13/1/2018, (10/1/2020), 17/7/2023, none had appeared for the petitioner. On 4/8/2023, Mr. Alan Dhinia, who appeared for the petitioner, submitted that the conducting counsel, Mr. K.K. Fukan, is not available and therefore adjournment. Today, when the matter is called again, none appears for the petitioner. List again on so in the event of further non-appearance, appropriate order shall follow. Presence to give appears for the respondents.
31.
One. IS civil. What is this IS civil?
Lordship, in respect of respondent number 3, service not found.
Sorry.
In respect of respondent number 3, service is not found.
Service not complete.
No.
No, what is the IA for?
IA is for stay.
Some stay.
Stay.
Who is respondent number 3? For whom do you appear, madam?
My lord, I am for respondent number 1, 2, and 5. My lord.
1, 2, and 5. Not for 3. Do you know? Do you know 3? চিনি পাইনে নাই? 3 কো নাপায়? আপনার ক্লায়েন্টে চিনি পাইনে নাই?
I have to take.
Ask your client whether they know respondent number 3. 5 years has gone by.
Right.
If this man is avoiding service, how long should he wait? If your respondent happens to know, we'll order notice to be served on 3 through respondent number 1. And why you are not able to serve?
We have taken steps to.
Steps, no doubt you have taken. Why you are not able to serve?
We have taken steps.
5 years have gone by. How long will you wait like this? It's stated by Mr. M.S. Alam, the counsel for the appellant petitioner, that notice could not be served on the respondent number 3. MS, your name? Nasreen. MS N. Nasreen, learned counsel for the appearing for respondent number 1, 2, and 5, shall confer with the respective respondents whether they know the respondent number 4 and his whereabouts, and inform the court. If you know, we'll serve it through you. Go and serve it.
Item 32.
Yes, Madam Chakraborty. 32.
This I is
Chatterjee, sorry.
is for the delay.
Sorry.
My lord.
Condoning the delay.
Yes, my lord. This case
How much your delay?
delay is for 788 days, my lord. Now question arises, my lord. The number of cases already dismissed on the basis of the judgment by the Honorable Court in Jasiruddin case, where the limitation of the Section 5 of Limitation Act is not applicable in the appeal filed against under Section 23 of the Railway Claim Tribunal Act. So it is under challenge before the Supreme Court. So the SLP already admitted. So it's pending with the Supreme Court to decide this issue, my lord.
Oh, but I is for condoning the delay.
Yes, my lord.
Why don't you proceed one step further, get the delay condoned, and then wait for Supreme Court?
That is absolutely fine.
Are you objecting to the delay being condoned? Your senior had not given you the instruction. He only said, matter pending in Supreme Court, tell that to the court.
My lord, there
With
is
your senior.
judgment, my lord. KP Maheshwari.
Huh?
KP Maheshwari.
KP Maheshwari.
I'm appearing on behalf of M. Sharma.
M. Sharma.
Yes, sir.
M. Sharma is your senior advocate.
But there's an amount of the Honorable Supreme Court in Umabai case. But
No, what is the issue, Madam Chakravarti? Whether Section 5 is applicable?
Or not. So I have received,
Okay, I understand. If Section 5 is applicable, this delay will be condoned. If not applicable,
delay will not be condoned.
not be condoned. That is pending before the Supreme Court.
Yes, my lord.
Stated by MSU Chakravarti and counsel for the appellant petitioner that the issue as to whether the provisions of Section 5 of the Limitation Act is applicable in respect of an appeal under the Railway Claims Tribunal Act is pending before the Honorable Supreme Court and it's yet to be adjudicated. In view of the such submission, adjourned to be listed again.
But it is, so I think Supreme Court, my lord, it will already been admitted.
33.
Pending for adjudication,
Yes, ma'am.
not admission. Or the learned counsel to inform the registry to get the matter listed as and when the Honorable Supreme Court decides the issue.
Yeah.
There is no point in listing from time to time.
But I have a decision of the Honorable Supreme Court, my lord. Already, the Honorable Supreme Court decided in favor of this railway on the ground that the limitation, section.
Then, one
Act
hand you
is
say-
applicable.
Madam Chakravarti, one hand you say decided, on the other hand you say pending. Which one should I do?
No.
Follow?
Since it is pending before the Supreme Court.
Let the Supreme Court decide. Yes, item number 33, who is appearing?
Item 33.
Apply still.
None appears for the appellant when the matter is called. List again.
34.
34.
Yeah, but I for substitution, my lord.
Hmm.
But as for office note, my lord.
IA for
Substitution, my lord. Respondent number 6, my lord.
respondent number 6, he died.
Yes, my lord, time.
Is the application in time?
Yes, my lord, time, my lord.
Suit is not yet abated.
Not yet.
May appeal not yet abated.
No, no, my.
When the person died?
He died, my lord.
When he died and when the application was filed?
My lord. My lord, died on, my lord, paragraph 4, my lord, page number 5, 18/6/2019.
18/6/2019.
My lord.
And this application is by the appellant.
Appellant.
Appellant. When you came to know about his
My
death?
lord, we came to know in the month of December 2020. My lord. My lord, I
Sorry,
have
give the
received-
dates, just a minute.
My lord, in paragraph number 4.
When he died, when you came to know, when you filed? When he died?
My lord, 18/6/2019. My lord.
18/6/19 died.
Yes,
When
my
you
lord.
came to know?
My lord, we came to know, my lord, last week of December 2020, my lord.
December 2020, you came to know. When the application was filed?
My lord, application filed, my lord.
Don't know. Heard Mr. T. Sheikh and counsel for the petition. For the appellant petitioner. IA to Dikwa 101/2021. RSA 2019 was instituted amongst others against who died? Respondent number 3.
My lord, this one number 6, my.
6 died.
My lord. Number 6. Name is Moina Malakar.
Amongst others, Moina Malakar as son of Bipin Malakar as respondent number 6. It is stated that Moina Malakar died on 18/6/2019. Accordingly, IAC case number 101/2021 has been instituted to substitute the legal heirs of the deceased respondent number 6, Moina Malakar. Where is your statement that he came to know in December?
Page number 5, my lord. Paragraph number 4, my lord.
In paragraph 4, in paragraph 3, it is stated that when the second appeal was listed on 1/12/2020, the appellants came to know from the office note dated 27/8/2020 that the respondent number 6 had died. Accordingly, we have to construe that the date of knowledge of the respondent number 6, Moina Malakar, of the petitioner appellant is 1/12/2020. The application under Order 22, Rule 4 of the CPC for substituting the legal heirs of the deceased Moina Malakar is date of filing colony. Sentence to is filed on 7/1/2021. From the facts narrated above, it is noticed that the application for substitution had been filed on time. Accordingly, the application for substitution is allowed. In place of Moina Malakar, respondent number 6 in RSA 19/2019, the names of the legal heirs, namely Niyoti Malakar, wife of Moina Malakar, Nibedita Malakar, daughter of Moina Malakar, Rajiv Malakar, son of Moina Malakar, Monita Malakar, daughter of Moina Malakar, Sitos alias Nonto Malakar, son of Sachindra Malakar. Why Sachindra? They are not legal heirs of Moina.
Yes, my lord, only 4, my lord. 6, 1, 2, 3, and 4.
Niyoti, Nivedita, Rajiv, and Monita
Monita, my.
Are impleaded as respondents number 61, 62, 63, and 64 in RSA 19/2019, registry to incorporate necessary correction in the cause title of RSA 2019 as well as in the CIS system. IA allowed as indicated above. Main appeal to Likivo, issue notice by registered post within 3 days upon respondents number 61, 63, 63, 64.
35.
35. What is to be done in 35? Sorry.
Last petition, time was for taking inspection as to whether the respondent number 2 shall appear to the present.
Office notes reference so far respondent 2 is concerned the same as returned back addressee not found. Who is respondent number 2?
Number 2.
Who is he?
He is the attorney holder of the present respondent number 1. To whom he has
Respondent number 2 is the attorney holder of respondent number 1.
original seller of the respondent number. Handler of the another
Seller. So respondent number 1 has purchased some land.
one has purchased the land from the respondent number 2.
2, that is the power of attorney
Attorney
holder.
holder of the handler of the respondent.
Of?
Respondent number 1. When the Dharmeshwar Sharma sold the land to respondent number 1 to the respondent number.
He is the purchaser.
But
Who is the appellant?
appellant is the my lord. He purchased the land, to land.
No, give a short answer because we can't hear so many things. So who is the appellant now?
Appellant is the
Respondent number 1 is the purchaser of a land
Right.
sold through the respondent number 2 power of attorney holder. Now who is the appellant now?
appellant is the purchaser of the stood land, purchased from a difference.
Okay, from another person.
Another.
So now the question is who is the genuine purchaser?
Right. And so far, my lord,
You have purchased from respondent number 2. You help us in serving him. Otherwise, you cannot frustrate the proceeding.
That's why kindly to order 24/7/2023.
We have seen it.
With thought time to take instruction whether we can appear for the respondent.
Sorry.
With what time?
Can we? Will you appear?
No, Lord.
Not
Till
appear.
that we have not taken.
Then you disclose the whereabouts of that person. Disclose the whereabouts of the person from whom you have purchased the land.
For my senior instruction, we need some time, 1 week or 2 weeks to take instruction.
The
so we can appear.
respondent number 1 to disclose the whereabouts and present location of respondent number 2 to enable the court for service of notice on respondent number 2. List fixed it. Tell us his address wherever he is there. Otherwise, you are a beneficiary of a fraudulent transaction. You may have purchased from a non-existent man also.
all right.
Item 36.
Please, your lordship.
BC. Yes, item 36.
Please, your lordship. We have already served on the other side, my lords, and the respondents had.
Maurya and Pancham Sharma.
I am
Who
Pancham.
appears for item 36?
I am
appearing? The volume is not there.
I am Pancham Surana, my lords.
Yeah, very well. You are appearing for the petitioner.
I am appearing for the petitioner.
Yes, what is to be done today?
We have already served on the other side and filed the acknowledgement slips, my lords.
Sorry.
And counsel for the bank had also appeared on all the previous occasions. It seems that they are not available today.
You are not very audible, Mr. Sharma.
The counsel for the bank had also.
Speak a little louder. You are not very audible.
Am I audible now, my lords?
Sorry.
Am I audible now, my lords?
Very faint.
Am I audible now, my lords?
That's why I say very faint. You are barely audible.
I'm not trying to raise my voice, but I'm trying to be a little
whether
louder,
your
my
audible
lords.
is audible to us, but what you are subsequently saying is not audible.
Okay. May I submit now with a little louder voice, my lords?
Please do it. Today, what do you want?
No, it is the reply ought to have been filed by the other side. They have not filed the reply.
Okay, who appears for the other side?
Mr. Parangam Goswami is appearing for the bank and for the other
Item number,
respondent.
just a minute. Item number 36.
Yes, my lords.
Not shown.
This is against Assam Valley Tea and Trading Company.
Yes,
It's
my
not a-
lord. So
it's not a bank.
if my lord sees the previous order sheets, the name of the opposite sides are written
We
there.
don't know which date.
It is
We can't go to
10th of.
all of the order sheet. Which date?
I'll just give you the date, my lords.
Order date?
11th August 2022.
Okay, heard Mr. Maurya issue notice, no formal notice on respondent number 7 as Mr. Goswami accepted. Petitioner takes steps on remaining registered post. Yes, after that, what happened?
After that, the matter was
Have you
listed
taken
again, my
steps?
lords.
Have you
Yeah,
taken or not taken?
We had taken steps and we had filed
Then
the
is it served or it is not served?
They have been served, my lords.
The petitioner to go through the office note dated 5/10/2023 as regards service of notice on the respondents number 1 to 6. List again.
The interim order may kindly be continued, my lords.
Interim order till next date. Mr. Sharma, you cannot online verify the order sheets. You have
Yes,
to put
Lords.
someone to go through the order sheet and then make your submission. Submission, you may make it online, we have no difficulty. But you should be of the knowledge of what is contained in the office note regarding service. Next item.
Item 37.
Yeah, but
Yes, IA 3497, what is it? Yeah, I'm ready to call you. Cover the order sheet or cover service which they cover one I likha ase. They'll go through it and say what they have to say. Yes. List the bench, matter any other bench without me. That's the only order. BC Chaudhary should be whatever. You are Mr. BC Chaudhary.
No, KL Gupta.
Sorry.
KL Gupta.
K?
KL Gupta.
Mo-
I'm newly engaged counsel.
You are newly engaged. You have not filed this.
No, my
I have no time.
my lord, in the left hand and the right hand side of the first matter, his name is appearing.
No, he is welcome. We have no difficulty with Mr. Mukhtar. But what is to be done today?
Lordship, both the IA has been disposed of. Our name is substituted. Already
Huh?
substituted. Names have been substituted, already substituted by last order. Now the
No, why have you filed IA 3497?
for substitute the name of the legal head.
Substituting the name of the legal heirs. Has that been done or it is yet to be done?
That has been done.
Done. So this is become infructuous. Mr.
KL Gupta.
K. Mukhtar, Learned Counsel, appearing for the
Gupta. KL Gupta.
correct number, please. Please write it in the piece of paper, so she writes it correct. I makes a statement that IA Civil 3497/2022 had been instituted for substituting the legal heirs of respondent number.
Amjad Ali.
1A, my lord.
No.
Amjad Ali.
Amjad Ali.
1A is Montu Ali. Who died?
Amjad Ali died.
His respondent number?
1A, my lord.
Respondent in the appeal.
Yes.
Appeal 1A.
Yes. In the appeal one.
So one have already died earlier.
Yes.
Now the substituted man also died.
Yes.
Very well. Okay, respondent number 1A in RSA 216/2011. When made this statement that it is also stated that the legal heirs of Amjad Ali, respondent number 1A in RSA, had already been substituted. In view of such statement, no further order required. IA closed.
My lord, the matter has matured and let it be for hearing, my lord, as per your lord.
Today?
No, not today, my lord. As per your.
We don't mind the hearing today. When do you want?
As your lordship.
Very key one, item number 37.
37.
37, item number 37, man.
Mr. A. Sattar, Learned Counsel for, even for the appellant or?
I am for the appellate.
For the appellant states that the matter, that the appeals can be given a final consideration in view of such a list on so and so for hearing. Okay, whichever is a convenient date.
Item 38.
Yes, 38, IA Civil. For what purpose?
Lordship, as per the Office Note 17/7/2023, Lordship, respondent number 2, 3, 5, and 10 expired. We need to file the substitution.
You want to file substitution?
Lordship.
Your name, madam?
A Das.
MS A. Das, Learned Counsel for the appellant states that respondents number?
Respondent number 2,
2, 3,
and
5, and
10.
10 had died during the pendency of the appeal. It's appeal, no? During the pendency, and therefore an adjournment is sought for filing appropriate application for substitution. Pray aloud.
Item 39.
Contempt. Which order is violated?
Aspect number 14.
Huh?
14, page number 14.
Page number
14,
14. Heard Mr. Satar, Land Council for the having issue notice, apparently directed shall not alienate the land. This order has been violated.
Alienate and not to construct.
And also shall not undertake construction. Heard
Yes,
Yes, I heard Mr. A. Sharma, Land Council for the petitioner. This contempt petition is instituted alleging willful and deliberate violation of the order dated 6/6/2023 in FAO 23/2023, wherein there is an interim order as extracted. It will page 14. The interim order is to the extent that during till the returnable date, the respondent shall not alienate the suit property nor shall undertake any construction work over the suit land. In paragraph, where is your statement that they are going undertaking construction? In paragraph 5 of the petition, it is stated that the respondent contemnors are undertaking construction work in violation of the order dated 6/6/2023. In view of the above, issue notice returnable 6 weeks, steps by raised to post 3 days. 40. We should reuse 40. IA 1641 for what purpose? Who had filed? Who had filed IA 1641? You have filed.
Too many miscases. Actually, what had happened, phone number 1, Dipali Basu died and she was unmarried.
No, we are in IA 1641.
That is the subsequent petition for substituting the heirs of the deceased proposed substituted heir. What had happened?
No, I understand. So who died?
No, response number 1 died.
What is the name?
Dipali Basu.
1 Dipali
Basu.
Dipali Bosu. Respondent number 1
She died
in RSA 161.
She died on 4th of July 2021.
4
4th of July 2021.
4/7/21 she died. And this application for substitution, and when you came to know?
What happened?
No. What is the date of your knowledge of the death?
No, before that I may be allowed to submit. What had happened, my lord? When she died, she was an unmarried lady. So, as per section 15, the heirs of her father are to be substituted. So, a petition was filed and there was delay. Since there was delay, I filed 3 miscases. 100, miscase 100, 101, 102. And in 101, that was for condonation of delay. This honorable court was pleased to issue notice. On 22nd February 2020.
Okay. In the meantime, that man also died.
That also died. So, to save limitation, this petition, IA Civil 1641 of 2022 was filed to bring his heirs on record. Prior to his substitution, he died. So, in fact, this
I'm sorry, we understood your problem. What is the law? What is the law in this respect?
Now, to whom to send notice, my lord? He is dead, my lord. He is dead. Proposed substituted.
Process server?
Proposed substituted heir.
No, we are asking whether such process service is available. Is it true to whom notice to send? Is there any such process server available? Who will serve?
When he also has.
Yes, Madam Devi, do you know any process server who will go and serve? No. That site? Otherwise, how will you serve? Any idea? Any known process server will go and serve? No. No, Chaudhary. That's why I'm asking you, what is the law in this aspect? X was the original respondent. X died. You wanted to substitute the legal heirs of X. Before it could be done, the legal heir also died.
Yes.
Now you are coming with the legal heir of the legal heir.
Yes.
What is the law?
My lord,
Hmm.
my humble.
Yes, what is the law? To substitute the legal heir of a legal heir who died before who could be substituted.